Good morning, everybody. Happy Wednesday. Welcome to the Courtroom Files Live. Let's start off our day with Judge Mom.
Okay, ma'am, please raise your right hand. You solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes.
All right, thank you. And you heard the plea that was placed on the record, correct?
Yes.
And as to the charge of possession of controlled substance, how do you plead?
Guilty.
You've gone over your advice of rights with your attorney, correct?
Yeah.
And you understand all of those rights.
Yes.
You also understand that by entering into a plea, that you'll be waiving some of those rights.
Yes.
You also understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes.
You also understand the 7411 status, correct?
Yes.
And knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
And any immigration issues?
No.
And counsel, if you can please order your client.
Just have the date, Your Honor.
August 18th.
On August 18th of 2025, you were in the city of Wyandotte.
Yes.
And at that time, you were driving a motor vehicle
Yes.
and you were pulled over by Wyandotte police.
Yes.
And at that stop, there was a search that was conducted of your person.
Yes.
And you were in possession of a single pill that's a controlled substance.
Yes.
And you don't have any legal right to possess that, correct?
Correct.
Satisfied, Your Honor?
All right, the court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the charge of possession of controlled substance and dismiss the no proof of insurance per the plea agreement. And you will receive a sentencing date and your pre-sentence interview date as well from probation. If you're to test right now, ma'am, what's in your system?
Nothing.
All right, Bodnick can just start continued, and counsel, hopefully we didn't hold you up too long, and just have the stop over at probation to get that date.
Thank you.
Have a good day. Thank you. Off the record. Yep. Damn it. Oh, there we go. Got it.
Probably.
No, that's okay. All right, I got that. Okay.
Yeah. You would tell us for sure.
Okay, and we are on the record in the matter of the city of Wyandotte versus John Kumashak. 251108 A.
Morning, Your Honor.
Good morning.
Your Honor, John Goldpaw, P 30758, on behalf of Mr. Commissioner, excuse me.
See, I even phonetically wrote it, and I should have put two E's to be me, and so just meh.
I just should remember what he told me when we were in meeting, talking.
Well, yes, it was much sooner that you spoke with him with his name, for
That's
sure.
correct.
Okay. All right, so sir, your name for the record, please.
John Andrew Commissioner.
Okay. All right, today's the date scheduled for sentencing on your client's plea of an amended charge of operating while visibly impaired by alcohol. The original charge of operating while intoxicated was dismissed by way of resolution between counsel as well as the speeding. 16 over, and so counsel, do you have an opportunity to review the report and recommendation with your client?
Yes, we have, Your Honor. There are no additions, deletions, or corrections to be made. At this time, we'd have the recommendation to be back. I have explained to him why early discharge termination. That's all.
Okay, all right, and so sir, if you're to test right now, what's in your system?
Nothing, Your Honor.
Okay. All right, sir. So you went to my place that night. Okay, let me clarify. My place bar and grill, not my place, meaning the judge's place. Okay. And so you went intending to have some drinks, right? Right. So why didn't you just take an Uber or a Lyft or just walk or, well, you can't walk. You're a little bit farther away. Wow, you came all the way from Washington Township to go to the bar?
I did. No, yes, I did.
Oh,
He came all the way from Washington Township. I don't think that was his original destination, or was it the original destination to go to the bar? It was. Oh, okay.
well, I mean, it's,
I'm pretty sure.
mhm. Interesting. Okay. Well, still, sir, I'm not sure why, you didn't either, try some other mode of transportation.
I should have that night, Your Honor.
Well, yes.
I did not. At the time, I didn't, I felt I was capable to drive.
Okay, well, now you know at what point you feel as though you're not capable to drive.
I sure,
And then dial it down about half, because you were a 0.153. So you're about double what that legal limit is. All right, and so, sir, you are employed with the union. Do you have consistent work, or are you kind of, some work or some not?
it's on and off. I also do side work for myself to keep busy.
Okay. And what type of side work do you do?
Carpentry, drywall, doors, finish, just about anything in a residential home.
Okay. All right, and, all right, and the court will note after hearing from Mr. Kamisha Sheck. Darn it, I'll get it right at the end of the day. The court does find there's reasonable grounds to depart from MCL 769.5. The court also finds the following sentence to be in the best interest of justice, to be reasonable and proportionate to the seriousness of the matter, taking into account the circumstances surrounding Mr. Kamishak and the legislative guidelines. The court's going to order 12 months probation. You're eligible for early discharge. And I'll go over that shortly. You are not to violate any criminal law of any government. You are not to leave the state without the consent of the court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, writing, or virtually. You notify your probation officer immediately any change in address or employment status. You are to not use any alcohol or drugs unless prescribed, to be subjected to random testing. The rehabilitative goal for that condition serves so the court can monitor your progress in maintaining abstinence and sobriety. I know you live a bit of a distance from the court, so you will be able to set up with somebody geographically more convenient for you. Okay? You are to enroll and participate in the chemical awareness program. The rehabilitative goal for that condition serves to further educate you about drug and alcohol use to allow you to make better informed decisions in the future. Hopefully prevent this matter from happening again. And then you are to participate in the MAD Victim Impact Panel. The rehabilitative goal for that condition is so that you could further increase your understanding of the dangers of driving while under the influence and the consequences of such decisions. The court's going to also order 40 hours of community service. The rehabilitative goal for that condition serves to help you further develop life skills and get back to the community. Any questions regarding those conditions?
There are.
The court's going to order a $300 fine, $100 screening assessment fee, $600 supervision oversight fee. That's $50 a month at 12 months. And since you're eligible for early discharge, up to half of that could be waived. $300 to the cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50, chemical awareness program of $75. It's a total of $1,500. You did post a bond, sir, and so you can set up the balance of your payment, the payment for the balance with probation if you're not able to pay it in full today. Okay?
Excellent. Thank you.
He does have some to pay today, but I guess we can work that.
Okay.
Thank you.
Well, so,
You have $200 to pay today?
yeah, okay, yeah. So since he doesn't have $700 to pay today,
No,
he can set up everything with probation. Okay.
That's right.
All right.
Okay.
And so, sir, as I did indicate, you're eligible for early discharge as long as all the following have occurred. You completed at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations, and all money has been paid in full or made a good faith effort toward making your payment in full. Okay?
Excellent.
All right.
Thank you.
You're welcome. Have a good day. Stop at probation. Thank you for addressing appropriately for court.
So I don't know about you guys, but I'm glad that Judge Mom clarified what she meant when she said the defendant, quote, went to my place that night. I was racking itself up to be one serious conflict of interest for sure. Good morning once again. Happy Wednesday. Welcome to the Courtroom Files Live. Good to have you here. Let's go to Texas. Judge Stevens.
If you look at the docket sheet, it was reset for to give him time to hire Mr. Rife Kimler.
Yeah,
And
how about that? Rife Kimler.
he's telling me
He
that
wasn't here Monday on trial docket.
well, he told me
Yeah, well, he can go hire anybody he wants, but this was something that you told me last time. You gonna hire somebody else or not?
we can speak to
We're gonna move forward one way or the other because this thing was indicted back in July. We gotta move forward on it. You can hire anybody you want. He's hired to represent you. I'm not gonna wait around. We're gonna move forward. But you can hire somebody, but I'm not gonna wait for you. It's an announcement. What do you want to do? You're the lawyer now unless something happens. But until that happens, you're still the lawyer. And it's an announcement.
what I would do, Judge, is
Mhm.
I was gonna actually give him Rife one more try, but if not, I'll just keep the case as though it's mine totally. And
What do you? Yeah, that's the way to. Yeah, unless until something else happens, you're the lawyer. But we're moving forward. I can't wait. I'm not waiting. It's the way it is. We just move forward.
No,
What do you want to do today? It's an announcement.
Can you give us one last and final announcement and no more, and then I'll just go from there. And if he doesn't want the plea, I'll go to trial. I'll take it.
There is an offer, Judge. I just don't think they've talked about it.
Mm-mm.
We
I said
talked
the
about
email.
Well, it's a time offer.
Oh.
It's not a probation. He's got priors.
Well, let's see. It's a state jail felony. State jail felony
2
conviction
years.
March of 23.
That's what I see.
March of 23.
Wait, hold on.
March of 23. It looks like it can only be enhanced to a third degree, right? Because these aren't sequential. It's all looks like
Well,
in March he picked up 3 convictions in Orange County at one time in
Yes, sir.
23.
2 state jails, whether they're sequenced or not, is third degree. That's it.
Yeah. So it's a state jail felony, but it's punished as though it were a third degree felony. So you're looking at up to 10 years in prison as though it were a third degree felony. You understand how that works? You have to speak up so she can hear and she can put it on the record that you're responding. Okay. That's a yes. He's nodding.
Yes.
He's not
Yes, sir.
responding orally,
I'm sorry.
which you have to do. Yeah. She can't.
Yes, sir.
Yeah, you have to respond orally. That's just the rules. But I know you're not happy about it, but you know, you're in a mess. Fix it though. It's fixable. This is fixable. What's this? What's the restitution on this?
It's a good question.
I don't have any requests from the complainant yet, but
Okay, so there's none.
it says the total of the theft was $11,800.
Did they get their stuff back, Langston? You know,
Did they get it back into the police report?
because
Right now.
there wouldn't be a restitution if they got the stuff.
Trailer was located on the side of a house. And do not show about the other stuff, but at least the trailer was found.
Yeah, it
It's
said
got to be the large amount, right?
Trailer was $1,500. The contents was $6,000.
Oh,
So,
carpet and tile.
Angela Livingston.
yes, sir. So it looks like they got the trailer back, but I don't know about the contents.
You know, Langston, if the other stuff was returned, do you know? Anybody know?
You know.
Mhm.
Looking at this police report, it looks like to me, it was, I'm looking on page 8 of the, here, Here we go.
He says he loaned it out to somebody at the time, but it was an unknown person who he won't talk about, which doesn't help. Was his stuff. But they also have a witness showing him driving. Driving. So
The only thing I saw is they said that the only thing that was missing from the trailer, Ramirez advised that there was a microwave missing from inside the trailer. So I'm assuming everything else was back. That's why
no, I
I'm
think
right
the
there.
trailer had something it was towing, wasn't it? Mine.
Yeah, there's
This is
his trailer was $6,000-7,000. Inside the trailer was about $6,200 in furniture. Ramirez advised there was a microwave missing from inside the trailer. So I don't know if I guess it was all inside the trailer when they found the trailer. I'll double check. That's Kyle's case. I'll have her double check. She'll be back Monday.
Well, that's that. If there's a loss, the court needs to get him to pay it back. But he can't pay it back because he's in prison.
Right.
He can only pay it back if
You don't
like
probation.
put him on like regular probation. And maybe that's something you don't want to
Well, it depends.
consider if we can get this
Because
stuff back.
with his prior, it's just hard to keep giving them probation just because they owe money.
Oh,
So let's just let's see if it was returned. I don't have a problem with whatever.
okay, I'll find out.
Yes, sir.
We can do that. Just one more announcement then, Judge.
Yeah. Okay, get it resetting. DeMarcus Jones. DeMarcus Jones, please. Is that you?
Yes, sir.
Who's your lawyer?
That's.
Yeah, he's not here. John Landry,
Sir.
you're here. Okay. Yesenia Alvarez.
Judge, that's reset. Mr. Gertz was in Montgomery County.
Raymond Renard.
That's also reset.
Is it reset? Do they need to be here? though?
It looks like she reset them before docket, so no. You're good. Yeah.
Well, Jose Aguilar.
He's here, Judge. Good morning.
Jose Aguilar. What is that translate?
Yes, he's here.
What
Morning, sir.
do we do?
Judge, it's an initial, so I'm still waiting on my media. I can have 4 meetings. Thank you.
Cameron Smith.
Judge, I'm in the process of talking to Miss Moore this morning. If we could just hold that to the end of docket and circle back to
Eric,
it.
okay.
Thank you, Judge.
Eric Arvino.
Yes, Judge.
Arvino.
We're getting paperwork, taken care of that. That was the one that was moved from last week.
Yes, sir.
Thanks, Judge.
you.
Good morning.
Caleb Mitchell. Okay. All right, so it will be set for trial. Who's the lawyer on that one? Mr. Ham?
Yes, sir.
Okay. Then it's set to trial.
Yes, sir.
And we're trying to move these a lot faster now, so especially if it involves firearms, so.
I slowed down on the crowd.
Okay.
What's that?
I get put on the trial docket. Thank you.
All right, fairly procedural so far with Judge Stevens, though it's interesting to hear that if it involves a firearm, they're trying to move it along faster. But I suppose they have to prioritize because, as we revealed on Sidebar last night, he has like 1,100 trials that are pending in a county that only has 250,000 people. So lots going on in Judge Stevens' court. Let's head back up to Michigan. We'll say good morning to Judge Simpson.
Case People versus Jennifer Gallara.
I apologize, Your Honor. I'm on the record for another court. I apologize.
You're in front of another judge? That they like better than me? Fine, no, we'll get right to it. Tomorrow. Court calls the case people versus Justin Chiachari. I probably pronounced that all wrong.
Good morning, Your Honor. Oscar Rodriguez for, I believe it's Justin Katari.
Katari, okay.
Yes.
And Mr. Katari, can you state your name, please, since both counsel and I have butchered it?
Yes, it's Justin Katari.
Okay, all right. Okay, and what are we doing on this?
Your Honor, today is the time set for sentencing in this case. And go ahead. We reviewed the recommendation of the probation officer, and sort of just generally speaking, my client wants to move on from this, and he knows he's made a mistake, and he can talk about that. But we have no issues with the recommendation of the probation officer. We think it's appropriate. I do want to add that there have been 5 months of complete compliance with absolutely no issues with the scram tether. My client has no problem continuing with that scram tether as directed by the court. And that's where we're at, to make it sort of short and sweet. He has a full-time job that he's had for quite some time. And look, this was more than a year and 5 months since, I believe, the incident. No issues as well. And Mr. Katari has learned a lot from this.
Mr. Katari, anything you want to tell the court before I impose sentence?
I would just like to say that I've definitely learned my lesson. Wearing this monitoring device and seeing my colleagues and the doctors that visit our lab, the way they look and treat me, I would honestly just like to move forward and prove to the court and yourself that whatever you deem is necessary, I will do.
All right. And I guess the good thing is, Mr. Terry, you can always look at this as being a bad thing, but the very fact of the level of your BAC and the fact that there was a crash of the vehicle, frankly, from my standpoint, I'm glad I'm here to be able to pronounce a sentence to you. Okay, and I think you understand what I mean by that.
Yeah, the Mothers Against Drunk Driving video really opened my eyes. That was a very good video.
Yeah. Kind of tells the truth of everything, doesn't it?
Yeah. Yes, sir.
Yeah. The court does acknowledge this is not a serious misdemeanor as defined by statute. However, it does believe that there are reasonable grounds to depart from the presumption of a non-probationary sentence. Specifically, the alcohol screening and assessment identifies the benefit of outpatient substance abuse treatment, attendance at AA meetings, and abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to prevent recidivism and monitor compliance of recommended treatment and to promote change. It's the sentence of the court. I'm going to place you on probation for a period of 18 months. You're to pay $855 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, and $540 probation oversight fees. When can you pay that, sir?
Today.
Today? All right. I'll put today, but just make sure it gets in by Friday, if you would.
Okay, not a problem.
Okay. There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random screening as requested by probation. You are to complete an outpatient substance abuse program, including all recommended aftercare with status reports to probation. You are to attend 2 AA meetings per week with monthly verification to probation. You're to provide proof of victims impact panel attendance to probation. I will continue to scram tether for an additional 30 days in lieu of 4 days in jail. I'll order 93 days in jail. Credit 1, the balance is suspended. All right. Thank you, folks.
Thank you, Your Honor.
Thank you.
Court does call the case, People versus Brandon Nash.
Well, they rack up that contestant. Good morning once again, everybody. Welcome to the Courtroom Files Live on a Wednesday, where, quite honestly, there's a lot of court going on around the United States right now, but not a lot of great court. But this is why you come to me. I sort through all the noise for you. So we're going to continue to ride with Judge Simpson for just a little bit.
You work? Okay, well, good luck on that. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $7,500. I'll give a 10% privilege on that. That warrant will issue immediately.
I spoke with him twice this week. I mean, I think he could be, there's a lot of weather problems out there, Judge.
Oh, you think it's the weather?
Could affect internet service.
Well, welcome to Michigan. All right, thank you. Court calls the case, People versus Nicholas Stimmel. Now, you know that if Rita Young made it here, there is no problem with the weather. I'm just, anybody's going to make it if she made it. Anyway, go ahead.
Thank you, Your Honor. Good morning, Rita Young, P44626, appearing on behalf of Mr. Nicholas Alexander Stimmel, sorry, who's present. Yeah. Sir, would you state your name for the record?
Nicholas Stimmel.
Thank you. All right. You read over the pre-sentence report?
Yes, Your Honor, we have read over it. There are no corrections. We are asking the court to adopt the recommendation of the probation department. And Mr. Stimmel did indicate that he can pay $555 today.
Yep.
Today.
All right. Sir, is there anything you'd like to say before I impose it?
I just look forward to satisfying the court. Thank you very much. Presumptively.
Yes. It's the sentence of the court. I'm going to place you on 12 months prosecutor deferred sentence. You are to pay $555 fines and court costs, $360 probation oversight fees. You can pay $555 today.
Yes.
And when can you pay the balance?
I was going to do it monthly. I can pay the entire balance. I can pay the entire, what is it, 910? I could pay the entirety today.
915.
But I thought that it was the probation was worked into it as well. So I just planned on monthly.
I just asked the question. When the man get paid? He told me he has the money today. Right? And then I don't know what he was talking about.
It's snowing outside.
Oh, it's snowing.
Well, I did
So
think
what
that
are
it
you
was,
trying to tell me?
I thought it was the monthly probation was worked into that.
It is. We like to get it up front.
Well, if you need to have your money up front, you can do that.
If it were my money, you'd be paying it right now. Can you pay it all today, sir?
That could be a whole other situation. You know?
Yes, it could. But you can pay it today?
Yes.
The whole of it?
Thank you.
Yes.
The whole thing. Thank you. There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete an anger management class as directed by probation. There is to be no contact with Reggie Harrell, directly or indirectly. There's to be no assaultive, threatening, or intimidating behavior on your part. You are not to possess any weapons, firearms, ammunition, or anything fashioned to be a weapon. I'll set a review hearing. That's to be held December 9th, 2026 at 9 a.m. I'll order 93 days in jail. That is suspended. All right. Thank you, sir.
Thank you.
Thank you so much, Your Honor.
Thank you, Ms. Young, and long time no see.
Yes, Judge.
And if you're not back before the holidays, please have a joyous, blessed, happy holiday.
Same to you and your staff as well, Judge, and thank you so very much. And I'll be back in the spring.
In the spring. Going into hibernation. I'll be back. Court calls the case. People versus Benjamin. Is it Tatro? Tatro.
Morning, Your Honor. For the record, Roger Cayley, P48811, appearing on behalf of Mr. Tatro, standing to my right.
Your name, sir?
Ben Tatro.
Go ahead, sir.
Your Honor, we have had the opportunity to review the progress report and the pre-sentence investigation report. It is accurate. The recommendations are fine with my client. I'd like to say a few words on his behalf.
You may.
Well, thank you, Judge. Mr. Tatro is actually taking this very seriously. He started attending AA in mid-July. He's probably attended 140 meetings. He's now chairing meetings once a week, sometimes twice. He's totally changed his life. In the meantime, obviously his driver's license was suspended for 30 days, so his main job is on hold for another couple of weeks. But he is currently working part-time for a snow removal company and things of that nature. He's learned a very valuable lesson from this judge, and we're asking you to adopt the recommendations.
Sir, is there anything you want to tell me before?
No, Your Honor.
All right. Court does acknowledge this is not a serious misdemeanor as defined by statute. However, it does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of outpatient substance abuse treatment, attendance at AA meetings, and abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. It is therefore the sentence of the court that you are placed on probation for a period of 12 months. You pay $855 fines and costs, $100 prosecution recovery cost, $100 police agency recovery cost, $360 probation oversight fees. When can you pay that, sir?
90 days, Your Honor.
Yeah. No. Do you have anything today?
I'm afraid not, Your Honor.
Okay. That's because of your work situation, is that?
Yes, sir.
The issue? All right. What I will do then is, I'll make this payable February 28th, 2026. Understood?
Yes, Your Honor.
There's to be no use of any alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete an outpatient substance abuse program, including all aftercare recommendations with status reports to probation. You're to attend 2 AA meetings per week with monthly verification to probation. You're to provide proof of victims' impact panel attendance to probation, continue the sober link for an additional 30 days in lieu of 4 days in jail. I'll order 93 days in jail. Credit 1, the balance is suspended. All right. Thank you, folks.
Thank you, Judge.
Thank you. Court does call the case. People versus Crystal Barnes.
Good morning, this is Public Defender Lauren Kearney on behalf of Ms. Barnes. Should be on Zoom.
Yes, she is. Ms. Barnes, can you state your name, please?
Crystal Denise Barnes.
Thank you.
And today is the date and time set for sentencing. We don't have any changes to the PSI, and we do ask that you adopt the recommendation.
Ms. Barnes, anything you want to say before I impose sentence?
No, sir.
All right. On count 1, the attempted resisting and obstructing, sentence of the court, 24 months probation, $555 fines and court costs, $720 probation oversight fees. I'll get to the payment in a while after I pronounce sentence on the rest of these. There is to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete the behavior modification class or comparable class. There's to be no assaultive or threatening or intimidating behavior on your part. You're not to possess any weapons, firearms, ammunition, or anything fashioned to be a weapon. I'll order 365 days in jail that is suspended. On count 2, the retail fraud second degree, 24 months probation, $480 fines and court costs, $299.90 restitution to Target payable through the court. You are not to go to any Target stores in the state of Michigan. You are to comply with all other terms as set forth in count 1, and I'll order 365 days in jail suspended on that count. On count 3, the assault and battery, I'll place you on 24 months probation, $555 fines and costs. You are to comply with all terms as set forth in count 1. I'll order 365 days in jail that is suspended.
Your Honor,
yes.
Count 3 is a 93-day offense.
That's an error. You're correct.
So if you could correct.
Yes, it's 93 days in jail suspended.
Thank you, Your Honor.
Thank you. All right, ma'am, how are you intending on getting these fines and costs and restitution paid?
I can pay $100 on Friday. Towards restitution, I'll need another 30 days for the balance.
So you can pay $100 Friday.
Friday.
That needs to be in cash and that's gonna go toward the restitution. Then how are you gonna get the rest of the fines and costs and everything paid? And the balance of the restitution?
What's the balance?
Somebody wanna give me a total? Hmm? $2,609.90.
Oh, no. I thought we were talking about what I have to pay to Target. I need a long time to pay that.
All right, so you'll owe $199.99 to Target after you pay the 100. When can you get that paid?
Now that I can get paid in the next 30 days. So I say
That the balance of the restitution, then after you pay the $100 on Friday, is going to be due by December, or by January 12th. 2026. The rest of the payments will be on a payment plan as arranged by probation.
okay.
Thank you.
Thank you.
Court calls case people versus Michael Bork.
Assistant Public Defender, Assistant Public Defender Natalie Pate with and on behalf of Mr. Burke, who is present via Zoom. Sir, can you please unmute, turn on your camera and state your name for the court?
Michael Burke.
Hello there, Your Honor. Sorry about that. Michael John Burke.
All right. Go ahead.
Thank you, Your Honor. Today's the date, time set for sentencing. We have had the opportunity to review the assessment as well as the recommendation. We are asking the court to adopt probation's recommendation. The only request I would make as for deviation from the recommendation is I would ask if the court would consider allowing the scram tether to discontinue at this point. To my understanding, Mr. Burke has been on it since July without any violations. So I would just ask if the court would possibly consider that. Other than that, we would ask
If he wants to come in and do 5 days, I will, but otherwise I'm not doing it.
Okay, Your Honor, I was just making the request. Otherwise we'd ask the court to adopt probation's recommendation.
Sir, anything you want to say before I impose sentence?
I just wanted to apologize for the issue that I caused back in May. I've had quite a bit of time to think about it and to also work on my substance abuse issues, and I'm looking forward to continuing.
Court does acknowledge this is not a serious misdemeanor as defined by statute, however, believes there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of outpatient substance abuse treatment. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. So therefore, the sentence of the court, I'll place you on 18 months probation. You are to pay $855 fines and court costs, $100 prosecution recovery cost, $100 police agency recovery cost, $540 probation oversight fees. When can you pay that, sir?
Your Honor, I can make a payment of $200 by Friday. And after that, it would probably be about a year before I could complete that payment in full.
So $200 will be paid this Friday, and then the balance will be on a payment plan as directed by probation. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete outpatient programming at key development, including all recommended aftercare with status reports to probation. You're to provide proof of victim impact panel attendance to probation. I will continue to scram tether for an additional 30 days in lieu of 5 days in jail. I'll order 93 days in jail, that is suspended. Thank you.
Thank you, Your Honor.
Thank you, Mr. Beer.
Court calls the case of the people versus Esther Caper. Or Kappa.
Good morning, everybody. Public Defender Lauren Kearney on behalf of Ms. Capper. Ms. Capper, state your name for the record, please.
Esther Capper.
Today is the date and time set for sentencing. We did review the pre-sentence report, don't have any changes. We do ask that you adopt the recommendation. I will say on behalf of Ms. Capper, this incident arose right around Christmas time. She was going through a very difficult time, including breast cancer treatment, and was looking for presents for her children. Since then, she's encountered some more struggles, but I know that she is not going to reoffend, or I hope that she's not. So, we don't know anything at this point.
Ma'am, anything you'd like to tell the court before I impose that?
No, sir.
All right. Sentence of the court, $480 fines and costs, 93 days of jail suspended. When can you get that paid, ma'am?
I can make a payment next week by next Friday, and then I'll set up a payment plan with them after.
Okay, what can you pay next Friday?
I would say at least $100 by next Friday.
How much did you say? You broke
100.
up. All right. $100 by the 19th. And then I need, how much are you going to pay each month, ma'am?
At least $100 each month.
And then I'll indicate $100 per month thereafter. Thank you.
Thank you, sir.
Court calls the case of the people versus Robert Greenshields. So you may have to sit down. Mr. Kilowald is not. He's not present. We have not heard from him yet. So if you have a way of getting contact with him, you may want to try to do that. Okay. Court does call the case of the people, recalls the case, people versus Jennifer Galera.
Good morning, Your Honor. Attorney Amber Lee, P84377, appearing on behalf of Ms. Galar, who appears via Zoom. Ms. Galar, can you please unmute and state your full name for the record, please?
Jennifer Galara.
All right. And it's okay, Miss Lee. I don't take offense because everybody was telling me like the other judge you were appearing before better than me. And so I just waited. With humility, I just waited. It's okay. It's okay.
Thank you, Your Honor. I apologize.
I'm not that sensitive. Go ahead.
Your Honor, we are in receipt of the recommendation. I did go over that with my client. We don't have any corrections to that.
Galera, is there anything you'd like to tell the court before I impose that?
Yes, Your Honor. I'm asking that you please don't give up on me. I do take full responsibility for my actions, and I'm truly committed to making real and lasting changes in my life. I've learned from my mistakes. I'm really grateful that nobody was hurt. Really grateful that you were my judge. You were brought into my life at a time that I needed you, so I'm thankful for that. And I just want to thank you for your time and giving me an opportunity to do better.
Well, thank you for those kind words. And Ms. Galera, the one thing that people know about me is it's going to be a rare circumstance that I'm ever going to give up on anybody. And certainly I'm not going to give up on you. I have faith that you're going to work your way through this and that in some way have this become something positive in your life. All right.
Thank you, Your Honor.
The court does acknowledge this is not a serious misdemeanor as defined by statute, however, does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. Specifically, the alcohol assessment, screening and assessment identifies the benefit of alcohol education and abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance with recommended treatment and continued sobriety. Therefore, the sentence of the court, I'm going to place you on 6 months probationary term. You are to pay $855 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, and $180 probation oversight fees. When can that be paid, ma'am?
This Friday, Your Honor.
Thank you. All right. Pay that by the 12th. There is to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete the alcohol highway safety education class, which you have completed. You're to provide proof of victims' impact panel attendance to probation. You also have completed that. I will continue this overlay for an additional 30 days in lieu of 5 days in jail. I'll order 93 days in jail. That is suspended.
Well, I was just about to have a drink of coffee, and then all of a sudden he just cuts his feed. Love when that happens. Thanks, Judge. Real quick, we're going to go to Judge Stevens, but before we do that, we started streaming this show last Friday on Kick. Obviously, we're on YouTube. We're also on Rumble. We're on X, but we added Kick, and the reception over there has been pretty good to start with. So good morning, all of you watching over on Kick right now. But what I'm asking is that if you are watching us on YouTube or another platform, do us a favor, go over to Kick and start following us over there as well. Kick.com/courtroom files. So take you right to us. We have an opportunity over there to really expand. We're really the only channel that's broadcasting court content like this over there. So I'd like to continue to expand that. Again, it's the reception over there has been good, and I'd like to continue to grow. So if you can help us out, kick.com/courtroom files. Go over there, create an account real quick if you don't have one, follow us, and that would be great. Okie dokie. Judge Stevens.
Waive a formal reading of this indictment and the arraignment here. Can we proceed in summary?
Yes, Judge.
In summary, this indictment alleges, sir, that on or about December 18th, of last year, 2024, in Jefferson County, Texas, you committed the third-degree felony of deadly conduct, discharge of a firearm. Do you understand what you're charged with here, sir?
Yes, sir.
It's almost a year.
Judge. And if you remember correctly, Judge, this is the one where he's also being charged with the family violence from the same incident.
Let me just tell you, I've got 5,000 cases. If you tell me to remember one, it's going to be hard unless I'm dealing with it immediately.
I understand. This is one, Mr. Ham is prosecutor on the case, and you had asked us if it was a double jeopardy issue because of the misdemeanor. We agree it's not, because the bullet inside the home hit the neighbor's house.
Okay.
That's the reason we'd be asking for 5 years on deferred.
All right. This is a third-degree felony. Do you understand, sir?
Yes, sir.
Which means you face no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
An agreement has been reached where you would be pleading guilty, placed on, but not found guilty, placed on deferred or unadjudicated probation. This can be up to 10 years in length. Do you understand what the potential is?
Yes, sir.
The fine would be $500, and there would be terms and conditions of probation, which are normal and customary for the circumstances of this offense. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, sir? Guilty. Guilty. Hold on. Now we're speaking over each other. Go ahead. How do you plead?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will, and because you are guilty.
Yes, sir.
I'll show you what's marked as State's Exhibit 1. Did you sign that document voluntarily?
Yes, sir.
Understand it? Discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
And without objection, it is admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment read to you. You've read it. You're agreeing with this length of time.
I don't have any objections, Judge.
You are.
Fair enough.
Well, I lost my train of thought there when I was. Mike does that to me. It's some psychological thing he pulls that throws me off.
We can work together.
You're mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and you are totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes, sir.
States Exhibit 1 is made a part of the record for all purposes. Pre-sentence report waived.
Yes, Judge.
I'm going to follow this agreement. If nothing further, I will find, sir, you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. Even though there's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, I am instead going to defer or postpone any finding of guilt so long as you follow the terms and conditions of probation that you're in this probation order. The probation officer will go over them with you. Please follow those. If you fail, your probation can be revoked. Then you could be found guilty and sentenced up to 10 years in prison. So you got to be careful. And these 90% of these conditions of probation are what your lawyer and I have to do. Follow it, like don't commit a crime, obey the rules, you know, the kinds of things that we all should do. And those are good things to be mindful of. You have more to lose than we do, though, if you fail. So get with the probation office, sign those, and you can begin probation.
Thank you, Judge.
You're very welcome.
Be dismissed.
Yes.
Thank you.
Okay. And job will 5 years. It's probated for 5 years. Okay, we have Jones and Landry. Okay, now we got a prosecutor. Great. What do you do? Do you have something for who? Good luck. I don't know why we're putting GPS devices on the defendants. We need them on the prosecutors.
I can use them. You don't use them.
All right. Well, they use GPS and other technologies to locate people that should be in the courtroom. Let's go back up to Judge Mom.
Morning, Richard T. Serrano, PG328. Your Honor, today I appear with MIDC counsel on behalf of my client, who appears to my right. And Your Honor, please state your name, sir.
Timothy Stevens. All right, good morning. Thank you for dressing appropriately for court. Today is the date scheduled for the jail review in this matter. And, well, it was on November 5th. Were you here November 5th?
I rescheduled it.
Right.
Okay, that's why it's here today. That note didn't get put in here. So that's why I was asking you.
To, and there wasn't a date in the system.
Okay, and so today is the date scheduled for the jail review. And counsel?
That's correct, Your Honor. I've reviewed the jail review recommendations with my client. They appear to be accurate. Just to bring the court update. My client tells me that he's aware that he still owes the court a balance of $660. Your Honor, you've heard it so many times before from other individuals. I've got a lot on my plate, or I'm very busy. This gentleman is very busy with court matters. He's on probation in both Wayne County and coordinated with Washington County. He's doing random drug or alcohol screens there. No violations. He is regularly attending voluntarily AA programs. He is treating with pure psychiatry, sees the therapist once a month. Your Honor, so he is taking this matter seriously. There's been no deviations from his treatment. He is on looking for work. He's unemployed, although he's just had a child in October. So more responsibility, more on his plate. What we're asking the court to do is to keep these jail days that were deferred initially to be continually deferred until or if that time comes where my client is charged. Or unfortunately, if there's a violation, I said the court can exercise its discretion and give you the jail time. So with that, Your Honor, I think my client wants to say just a couple of words and then we'll leave it in the court's discretion.
Okay,
Sure.
I don't know. I'm trying to do my best.
okay, so here's a couple questions I have for you, sir. Number one, I understand that you're attending AA meetings and peer psychiatry. You have not provided any proof of that. So where is the confirmation that you have been attending those?
I couldn't find it in my email. I was supposed to have a letter sent to my email from Pure Psychiatry for proof, but I can't find it anywhere, so I'm gonna go get a hard copy today.
Okay, well, you knew you had this today. Why didn't you try to do that before today?
Because I was up north for trying to work.
Where was that?
The weather was bad.
Where?
Manistee,
Okay, and what do you do that you need the weather to be bad for work?
construction, exterior, so
So you went out north for exterior construction when they've been getting pummeled with snow?
well, I was planning on working if I could.
It's in the state, Your Honor. It was leaving the state.
I understand that. I'm just trying to understand what his statement was because,
I was just trying to be available for work.
oh. Do you work up north?
Yeah, I've been working up once. But it got pretty much laid off in the winter for the most part.
Right, so why would you expend money for gas if you don't even have any confirmed work up there?
Because I was playing it by ear, I wasn't told that there wouldn't be for sure.
Okay. And so, sir, when's the last time, it shows your balance is $660. When's the last time you made a payment, sir?
Last week, I think,
Okay, and before that?
I believe. The last court date I was here,
Okay, are you paying every month?
I'm gonna be paying at least 50.
So the answer is no, you have not been paying every month.
I forgot I was obligated to pay monthly payments here,
Okay, so how much are you paying per month?
at least 50. Definitely don't want to get another late fee.
All right, what date of the month is, are you making your payments? Or are you planning on making your $50 per month payments, sir?
Beginning, middle, or end.
Probably the beginning.
So how about we make sure that we just pick a date, January 9th?
That's fine.
And you haven't violated your other probations, have you? And so, here's what the court's going to do. Going to have you submit your documentation regarding, do you have somebody sign into your AA meetings?
No, because I'm pretty much done.
Okay.
Would you like something from AA, Your Honor?
No, not necessarily. I do want something from Pure Psychiatry, right? So that's confirming that you've been attending, how often you attend, and that's about it. Okay. All right, and then we will adjourn this to February 18th. You're on the date, council.
8:30?
That should be fine. 8:30 a.m.
Thank you.
Okay. Have a good day. You can just email that in too, okay?
Sure. Thank you, Your Honor.
Yeah, let's go off the record.
Jessica Alexis was scheduled for 8:45 sentence.
Yep, right here.
Her attorney, Theo, Tello, whatever, is house counsel in 33rd. And she was wondering if it would be possible to maybe get one of the other MIDC attorneys to, because she said she.
So given that defendant's selective memory loss, I think this dovetails greatly into the sponsor for this hour of the program, and that's Prescription Forget-A-Boutics. Do you lie awake at night haunted by the one thing you said in 2009 at a party that no one else remembers? Introducing Forget-A-Boutics, the world's first fictional medication for highly selective memory loss. With just one imaginary dose of Forget-A-Boutics, you can finally let go of the time you waved back at someone who wasn't waving at you, every reply all you regret, and yes, your karaoke version of Bohemian Rhapsody. Side effects may include absolutely nothing because this product does not exist. Forget-A-Boutics is not FDA approved, not doctor recommended, and should not be taken, purchased, or even looked for. Ask your doctor about Forget-A-Boutics. Anywho, lame attempt to be funny. Enjoy. Let's go back to Judge Stevens.
We have a formal reading of the indictment and arraignment. Can we proceed in summary?
He does with Your Honor.
In summary, this indictment alleges that on or about December 6th, 2024, in Jefferson County, Texas, you committed the state jail felony of injury to a child. Do you understand what you're charged with here?
Yes, I do.
Okay. It's a state jail felony, which means if convicted, you face no less than 180 days up to 2 years in state jail, and a fine up to $10,000 can be assessed. Do you understand the punishment range applicable for this type of offense?
Yes, I do.
An agreement's been reached where you would be pleading guilty, placed on deferred or unadjudicated. Is that a 5?
500.
Just going with that. I'm gonna make it a 5 that I recognize. Placed on deferred or unadjudicated probation, $500, and there will be terms and conditions of probation, which are normal and customary. What is this? 55A, is that the Texas Code of Criminal Procedure?
It is, Your Honor.
Okay. And summarize. Help me out.
That agreement states that if he completes his probation successfully and does not have any revocations, then the state of Texas will not object to him getting an expunction. It'll still be discretionary with the judge, but we just won't object to it.
All right. Is all this your understanding of the agreement, sir?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily?
Yes,
That
sir.
is on your own free will and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Are the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence?
No objection.
Without objection, it's admitted. Among other things, the state you are mentally confident to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses, and you were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true. So help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
We'll waive, Your Honor.
I will follow this agreement, and I will find that you are mentally competent to enter your guilty plea. It's freely and voluntarily made in this case. You understand and appreciate the consequences of pleading guilty.
Yes, sir.
There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted to find you guilty beyond a reasonable doubt. But I'm going to defer any finding of guilt instead and place you on deferred or unadjudicated probation for 5 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. Make sure you review them and understand them fully, as you're going to meet with the probation officer. If you fail, your probation could be revoked. You could be then found guilty and sentenced up to 2 years in the state jail, and it's a felony conviction, which would be final, which follows you around the rest of your life. So that's, avoid that. One of the conditions of probation, a parenting class is going to be ordered that helps. That's a good thing. Everybody ought to take it, really, as a parent. It helps remind you of the important things about children being first and the importance of their well-being and how you are responsible for making them the most successful they can be. And that helps you be a good parent. Good luck. Please see the probation officer, okay? Thank you. All right, you're in recess.
Okie dokie. Judge Simpson's back online. Let's go there.
Today.
I'm the next get one in your second. Mr. Davis.
No. Court does call the case, People versus Christopher Fair.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Fair, who stands to my right. Please state your name for the record, sir.
Christopher Fair.
Thank you, Your Honor. Today's the date and time for sentencing. Mr. Fair and I have had the opportunity and did review the PSI, and we have no material changes. And we would also ask that the court adopt probation's recommendation in this case.
All right. Sir, anything you want to tell me before I impose that? No, sir. No? Sentence to the court, $125 statutory fee, 120 days in jail, credit 43 served, defendant to serve the balance. Right.
Thank you, Your Honor.
Court does call the case, People versus, oh, no, he's in too. Court does call the case, People versus Man Davis.
Edward Jones for Man Davis.
I don't know what that is. What is that? Mr. Davis, can you hear me?
Yeah.
Okay. State your name for me, sir.
Man Davis.
Thank you. Go ahead, Mr. Drukas.
Thank you, Your Honor. I've been able to go over the pre-sentence report with Mr. Davis. There are no material changes or corrections. We're asking the court to follow the recommendation. I just want to briefly allocute on his behalf.
No idea what that is.
Take him up on the jail.
Hmm? Outside is.
Yeah.
All right. Mr. Davis, is there anything you want to tell me before I impose sentence?
No, Your Honor.
All right, thank you. Can you get somebody to? It's a sentence of the court, $125 statutory fee, $1,137.11 restitution to Meyer payable through the court. I will order 365 days in jail, credit 218 days served, defendant to serve the balance. I will consider early release to inpatient treatment. I'll make the restitution payable. I'm just going to indicate 90 days after release. All right.
Thank you, Your Honor.
Thank you. Thank you, Mr. Davis. Court calls the case of the People versus Leo Stringa.
Assistant Public Defender Natalie, Mr. Stringa, who stands to my right. Please state your name for the record, sir.
Leo Stringa.
Thank you, Your Honor. Today's the date and time for, well, 2 cases are set for sentencing and 2 cases are set for violation of probation. I have had the opportunity to review the alleged violations and the recommendations as to the violations of probation with Mr. Stringa. I guess I will start with those first, Your Honor, if Your Honor does not mind.
Go ahead.
We do acknowledge that there are the new criminal convictions and new pending criminal matters. And we do acknowledge that no proof of these things have been sent to probation. Mr. Stringa did indicate to me that he was going to try to get proof of Dawn Farm outpatient treatment. However, unfortunately, I have not received that yet to provide to probation or to the court. We are asking, as far as these cases go, the court would consider not remanding Mr. Stringa. We do acknowledge that, yes, there are several violations alleged, and there's no getting around that. I'm just asking that the court, if you would consider not imposing the jail time. He does have some significant medical concerns he has been dealing with, and we are just asking if the court would consider not imposing the jail. And we do, as far as this 2 cases set for sentencing, Your Honor, I do not have any material changes to the PSI. As to the recommendation, my request would be similar. I would ask if the court would consider not imposing the jail time.
Stringer, anything you want to, Ms. Clara?
Yeah, sure, Honor. Teresa Clara on behalf of probation. Your Honor, I would just like to make the court aware, it already knows. Mr. Stringa has been on probation for over the last year on the 2 DOC cases. In those cases, he's done nothing. He's not paid 1 cent on either case or record that is owed, that is high amounts on both cases. The only thing that Mr. Stringa has done is picked up new criminal cases. He has convictions, he also has pending matters. I had conversations with Mr. Stringa about getting into treatment. Conversations go that he agrees. He's supposed to be getting into verification. He's doing these things. Probation never receives anything from Mr. Stringa. So those just go on, and he stays in non-compliance. Given his past behavior and his continued criminal behavior, probation is asking that the court follow the recommendation for a jail sentence.
Mr. Stringer, anything you want to say?
Yes, Your Honor. As far as my current situation, I've been in and out of the hospital like 32 times. University of Michigan Hospital has cited. I've supplied the court with multiple, documentations of my current medical situation. My knee's bleeding through my pants right now. I have osteomyelitis. My bone's infected in my leg. I didn't.
In that regard, and I don't mean to interrupt you, but
yeah,
in that regard, part of you haven't done any testing, you haven't done anything. Part of your reasoning behind that is basically saying you can't go out in public.
Right, Your Honor.
Well, we have your tracking, and you've been out in public. What were you doing at Briarwood yesterday?
I was trying to apply for a job online that I'm trying to do online. I had to go there and give them some paperwork.
Then why couldn't you go to community corrections?
I could, Your Honor. I don't have any money to pay for it. But I am so.
What you want to say?
But I do have a PhD from Michigan, and I am a professor. I was on FMLA from Eastern, but I'm slated to go back. Hopefully, I can do this in January 9th, so I'll be able to create an income. I have been sober. I tried to go to inpatient treatment. They wouldn't let me because of my skin condition, just to show the court that I was doing something. And I did send some paperwork with that. I don't know if you didn't get it, but okay. Judge Barr's court got it, but yeah, I made a lot of bad choices earlier in my life. I mean, not earlier in my life, earlier with these cases, but I'm on the other side of it as far as me as a person and me continuing to try to do better. I made a mess of the cases, and I didn't know that I was still actually on probation in this case. And it wasn't even really brought to my attention that I wasn't in compliance until I spoke with Ms. Polera maybe 2 months ago. So I thought I might have had time served on this, but it was another case that it was time served on. But I would just like to for you to give me a chance that I can do probation, and that I can get through this and make myself a better person. I have so much going on medically right now too. I might, it's a lot. I don't want to get into it, but I'm at your mercy, Your Honor. I didn't, and this too, it's like, I didn't work so hard my whole life, and, get a PhD and do all these things in life to throw it all away. And I want the opportunity to try to do this. And if you give me this chance, I won't prove you wrong.
You were sentenced originally in July 24th of 2024. Now here we are a year plus, almost a year and a half later, and you've done nothing except, as Ms. Blair indicates, is pick up new criminal charges.
Right, I thought
I'm done.
I thought I was time served. I thought the case was over with, Your Honor. I really did. Until I spoke with Ms. Polera 2 months ago, I didn't even know the case was still active. I made a mess, and I had like 4 or 5 retail frauds in Washtenaw County through different 14A, 14B, and 15th. I didn't know which one was which. And when I thought I had time served, I thought it was closed out because nobody told me anything different. And actually, I went to jail, was booked, and let go multiple times, and I never even had a warrant on this case. So I didn't even know that I wasn't in compliance. I didn't even know it existed.
You done?
Yes, sir.
So on the cases ending in 0962 and in 1452, since they have the same recommendation, I'll just do it once. On those, the probation cases, I'm going to revoke your probation. I'm going to sentence you to 365 days in jail, credit 82 days served, defendant to serve the balance. I will waive the remaining terms, accept the financial obligations, discharge you from probation without improvement. I will consider release to Dawn Farm inpatient treatment on those cases.
Thank you, Your Honor.
On the other matters, on the case ending in 0616, $125 statutory fee, 365 days in jail, credit 41 served, defendant to serve the balance. I'll consider release to Dawn Farm inpatient treatment. And on the last case ending in 1677, I'll order $125 statutory fee. I will apply the bond in that case. I'll order 365 days in jail, credit 2 days on that case, defendant to serve the balance. I'll consider release to Dawn Farm inpatient.
Your Honor,
it is remanded.
Your Honor, may I say one thing? Just as far as the inpatient treatment, I have a misdemeanor warrant in another county, which I don't think they'll let me do. Is there any way I could do the Dawn Farms in jail program to get released that way? Is that feasible? Just because I know that you gave me bond conditions before to be released to treatment, and they wouldn't let me go because I said I had a misdemeanor warrant in another county. So I
consider that another time, but I pronounced my sentence. Defendant remanded.
Okay. Thank you, Your Honor. My coat. Thank you.
I just have one thing to say to this, and I'm going to quote the great Patrick Starr, who once said, "Liar, liar, plants for hire." What a liar. Back to Judge.
Under Natalie Pate on behalf of Mr. Max Stewart. Stand sir, right? Please state your name for the record, sir.
Hezekiah Max Stewart.
Thank you, Your Honor. This is a show cause, Your Honor, on a closed case where there still is a balance, I believe, around 400 and something. I think 460. Mr. Max Stewart is being held on other matters. I know he has a court date on the 15th, is my understanding.
15th.
Yes.
Are they felony matters?
Yes, Your Honor. So as to this, Your Honor, I did double check again this morning. This case is not holding him. I would ask for an adjournment.
What kind of cases are those other ones?
One, I believe, at least what I saw in X jail was that it was a violation of probation. I believe in circuit court, and that one had the bond denied. And the other one, I do not remember what the charge was on the felony file.
Anything you want to say, sir?
No, sir.
You know, he'll keep coming back, and I don't know. Well,
I'm gonna be here at least until July.
Yeah, that's what I I wasn't gonna kind of say all that out loud, but I hear you, right? And so that's why I'm gonna do what I'm gonna do. I'm waiving all but the $125 statutory fees. I'm just gonna close this out. Quit bringing me up here like, when are you gonna pay you?
Thank you.
I don't know that they're paying you in jail.
Mhm.
Are they?
No, sir.
No, okay. Oh, no, things change, so I was just checking. All right, Mr. Dexter, good luck to you.
Thank you. You have a good day.
Court does call the case of the people versus Julius Holston.
Under Natalie Kay for Mr. Holston. Your Honor, I do not believe this is present unless they are on the Zoom.
Holston? I got one unnamed. That's not, it's a ceiling fan. Anyway.
Your Honor, yes, I was unsuccessful in reaching Mr. Holston. From what I could see, I believe this was a review for payments on a closed case, and I believe it was a balance of 588. All that being said, I was unsuccessful in reaching that successfully, so I would ask for an adjournment for the record of this.
We've been issuing bench warrants now. This is now be the third one recently, or well, no. Every year here. Bench warrant will issue 5,000. I'll give it 10% privilege. That warrant will issue immediately. Court does call the case people versus Orleana Dela. Is that? I don't know. There.
Teresa Clara on behalf of probation. Your Honor, Ms. De La Rosa is scheduled before the court for a review hearing on a prosecutor deferred sentence. She did complete all terms ordered by the court, and I did wait for appearance. Probation is recommending that the court dismiss the case to the prosecutor deferred, discharge her from probation with improvement.
Hearing no objection, so ordered. Court does call the case of the people versus Michael Holbrook.
Mr. Holbrook, Your Honor, who I do not believe is present either. Likewise, as he today. That being said, I do not have an explanation for the record. I have a question.
Teresa Clara on behalf of probation. Your Honor, Mr. Holbrook was scheduled for the court for a violation of probation hearing. He's had multiple prior violations of probation hearings in the past where he failed to appear. Given his non-appearance today, probation is requesting a bench warrant.
Bench warrant will issue bond 20,000, 10% privilege. Warrant will issue immediately.
Thank you, Your Honor.
Court calls the case of the people versus Renee Scholl.
Clear on behalf of probation. Your Honor, Ms. Scholl was scheduled before the court today for a review hearing on a prosecutor deferred sentence. She did complete all terms ordered by the court. Probation is recommending that the court dismiss the case pursuant to the deferred and discharge from probation with improvement.
No.
So ordered. Court calls the case of people versus Arthur Myers.
Public Defender Natalie Kay, Mr. Myers.
Your Honor, this case was set before the court today for the next hearing. Mr. Myers is deceased. The court probation has provided the documentation that they received there.
Yes.
Given that probation is asking that the court recall the bench warrant in this case, waive the outstanding balance, and discharge him from probation without improvement.
Court will recall the bench warrant. I'll waive it. Any remaining outstanding balance, discharge from probation without improvement, and close this case. Thank you. Is that it?
So the deceased gets discharged without improvement. I suppose. Let's go back to Judge DeSanto.
All right, we are on the record in the matter of the City of Wyandotte versus Brandon DeBoard, 251465 A and B. And counsel?
Your Honor, good morning. Richard P. Serrano, P. 33828. Your Honor, today I appear with my client, appears to my right, purpose of sentencing. And sir, please state your name for the record.
Brandon DeBoard.
Okay. And good morning. Today is the date scheduled for sentencing on your client's plea to an amended charge of operating while visibly impaired and another amended charge of no operator's license on person. The original charge of operating while intoxicated, driving while license suspended, and then the charge of no insurance were all dismissed by way of resolution between council. And Mr. Serrano, did you have an opportunity to review the report and recommendation with your client?
Yes, Your Honor, we have gone over it together. He tells me it is factually accurate. There are a couple matters. My client wants the court to know that he did do 33 days in custody for this case in jail. He did not post a bond or get out. He has continuously been wearing a tether. The cost of that is about $120 a month. You're asking the court deemed it fit. If not today, then in the future, if he can possibly get that tether off. He's had no violations, Your Honor, pending today's date. And we would hope that the court would adopt the recommendations. Your Honor, he's a UAW iron worker full-time. He has one child, 33 years old. He's not the custodial parent. They share. And he is, in the past, he's treated for mental health, but he's good with that now. He attends the AA. He has a sponsor. He attends some youth where he's doing this without being ordered to do it. And Your Honor, he is, quite frankly, he acknowledges problems with alcohol. He's had problems in the past with substance abuse, but he's doing well. I think that the court allows him to be in a probationary period, that he will abide by the court's orders. We are going to need a payment program. And Your Honor, with that, we leave it in the court's discretion. Thank you.
All right, so, Mr. DeBoard, please tell me what's happening with your matter in the 18th District Court in Westland.
That I am taking care of.
I don't know what taking care of tomorrow means.
Okay, I'm going to court tomorrow.
Okay, so what stage of the process is it? Arraignment, pretrial,
I believe it's the end. Should be the end.
sentencing?
Yeah. I really don't know, but I do know I'm in court tomorrow.
Well, hold on a minute, sir. Did you plead to something or did you not plead? Did you plead guilty to something?
Yeah, I did.
Yes?
Tell the court what it was.
Oh, it was entering without permission.
Okay. And so tomorrow's the sentencing. Okay.
Are you represented by counsel there? Is that yes? Yes. All right.
And sir, what's the status of your license?
It is suspended.
Okay, so how'd you get here today?
Oh, my grandmother
Where's your grandmother?
out in the her vehicle.
Did you tell me so that you have restricted driving privileges?
Yes, I know it's suspended until tomorrow and then it's restricted.
Oh, okay.
So sir, you're very close. I certainly hope that you did not drive here.
No.
Because you're one day away from getting that restricted license.
My grandma is out there.
Okay, very good.
Yeah. You.
Okay, so then, all right, well, going to change what I'm doing on count B then. All right, the court will order after hearing from Mr. DeBoer, hearing from counsel, reviewing the report, the recommendation. The court does find that there's reasonable grounds to depart from MCL 769.5. The court's going to also find that the following sentence is the best interest of justice, is reasonable proportionate to the seriousness of the matter, taking into account the circumstances surrounding Mr. DeBoer and the legislative guidelines. Sir, you don't live in the area, so what brought you to Wyandotte that day?
I'll coming out to see a friend.
You were what?
Coming out to see a friend.
Should have taken an Uber or a Lyft
Yeah.
or some other, a bus, something.
100% agree.
All right, and so, and if you were to test right now, sir, what's in your system? The court's going to order 12 months probation. You're eligible for early discharge, and I'll go over that shortly. You're not to violate any criminal law of any unit of government. You're not to leave the state without the consent of the court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, writing, or virtually. You're to notify your probation officer immediately of any change in address or employment status. You're not to use any alcohol or drugs unless prescribed to be subjected to random testing The rehabilitative goal for that condition is so the court can monitor your progress in maintaining abstinence and sobriety. The court's going to also order you to participate in outpatient substance use counseling. The rehabilitative goal for that condition, sir, is so that you can have assistance in obtaining coping mechanisms so you can maintain sobriety and prevent relapse, hopefully preventing this matter from happening again. You'll have to enroll and participate in the MAD Victim Impact Panel. The rehabilitative goal for that condition, sir, is so you can further understand the consequences of the dangers of driving while under the influence. The court's going to also order the fan meetings once per month. The rehabilitative goal for that condition, sir, so that you can have additional support in maintaining sobriety as well as additional recovery resources. There's actually a Western Lane chapter not too far from where you live. Okay? I think those are on Monday evenings. I think it's one Monday a month. Okay? And then the court's going to also order 5 days on the court workforce. The rehabilitative goal for that condition is so that you can further develop life skills and get back to the community. Now, all those are on count A only. I was going to put a count B condition for probation of obtaining a driver's license, but since you're upgraded to restricted tomorrow, I'm not going to do that. I'm just going to order fines and costs on count B. Okay. All right. The court's going to order the following fines and costs. A $300 fine, $100 screening assessment fee, $600 supervision oversight fee. That's $50 a month for 12 months. Since you're eligible for early discharge, sir, up to half of that could be waived. $300 for the cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50, workforce of $200. It's $50, 5 days at $40 a day. So that's a total of $1,625. As to count B, the no ops, $100 fine, $200 cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50, for a total of $425. So the total between both, sir, is $2,050. Okay? You did post a bond. Nope. Well, it's in Robert DeBoard's name. So, okay, if he wants to assess that or sign that over to your fines and costs, he'll have to sign a document. Otherwise, you'll be responsible for that portion of it. So you can set up a payment plan with probation. Okay? As I did indicate, sir, you're eligible for early discharge as long as all of the following have occurred. You complete at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations. All monies have been either paid in full or you've made a good faith effort toward making full payment. All right. Do you have any questions, sir?
No.
Okay.
Your Honor, regarding the tether,
Oh, I'm sorry. Also, 33 days jail credit for 33 days and the court will remove the tether. Thank you. That's the alcohol tether, correct?
that was only alcohol, Frank's, all right.
All right. Any questions?
No.
Okay.
Thank you.
All right. Thank you. Have a good day. Please stop over at probation. Somebody will be with you shortly.
Not going back? I'll be back.
All right, be careful.
Thank you.
Okay, friends, I've got eyes on 14 different courts at the moment. But again, it's a lot of court today, but not a lot of compelling court. So just trying to sort through what makes the most sense. But let's change it up and go to Louisiana and see what's going on with the board over there this morning.
Morning. The Louisiana Committee on Parole is headquartered in Baton Rouge today, which is December 10th, 2025. On the panel today, to my left is Chuck Tillis, to my right is Danny Barra. I'm Jerry Ledoux. With the staff here at headquarters, announce yourself.
Jasmine Thompson.
Jasmine Cavalier. And our remote facility is Calcasieu Correctional Center. Is there any staff in the room?
Yes, ma'am.
Would you identify yourself?
Deputy Robertson.
Okay. So the first offender we're going to be hearing this morning for revocation, Christopher Amrine, would you please introduce yourself with your DSC number, please?
My name is Christopher Amron, DSC number 619279.
Amrine. Okay. Mr. Amrine, do you have a form in front of you that you signed? It's a parole questionnaire in front of you. Okay, your signature on that form indicates that you're not eligible for appointed counsel. Have you hired an attorney?
No, ma'am, I didn't have a way to afford one.
Okay. So what's going to happen is I'm going to be reading some parole revocation violations against you. And I need you to enter a plea of guilty, guilty with a statement, or not guilty. Okay. Okay, it is alleged that you failed to submit monthly supervision reports for the months of May, June, and July of 2025. You were directed to report to the Lake Charles District Probation and Parole Office for an appointment which was scheduled 7/28/25, but you failed to report, and your whereabouts were unknown, and a warrant was signed on 7/31/2025. How do you plead to that?
Not guilty.
Not guilty. Allegation number 4, you engaged in criminal conduct which resulted in your being charged by the Calcasieu Parish Sheriff's Office with attempted simple burglary, and that charge is currently pending. Pre-trial conference is 2/18/2026. How do you plead?
Not guilty.
Number 10, as of 9/5/2025, when you were detained, you have a supervision fee arrearage of $945. You never made a payment. How do you plead?
Not guilty, I did make a payment.
Okay, do you dispute that it's $945?
No, that, it should be around there. I just got a job, so I knew it was in the rear, but I didn't know how much it was.
Okay, so you're guilty for it being in arrears.
Yes, ma'am. I mean, I had no control of that. I wasn't working. I went back to the treatment place where I was at, where they was housing me, and they was also giving me a job. So that part of it, I wasn't aware of it being that much.
Okay, so we'll put guilty there. Mr. Barra would like to ask you some questions at this time. And we do also have someone in support, and I'll allow Mr. Barra to call on them at the appropriate time.
All right. Mr. Emery, I'm looking at the preliminary hearing where you and the officer had a little hearing in the jail. And at that hearing, for number 2, you said Mr. Emery admitted to not reporting for the designated months and stated his reason for not reporting was that he did not have transportation. Officer Anderson provided case narratives that indicated Emery failed to report on the occasions listed, and he provided a copy of the parole warrant that was issued. So you admitted it then, and you're saying you're not guilty now. What's the difference? What's changed?
Okay, all right, so on April 30th, I got a parole pass to work in South Dakota for 6 months. I was supposed to return in November. Well, he told me just to send a message in. Well, on May 2nd, he came to my house in Sulphur and come to see me on May 2nd at my house. They told me that he was my new parole officer, wasn't Officer Myers no more. After that, it was May, June, and July. So June and July, I probably didn't check in exactly because I was working for a fair right there in Raceland, Louisiana. And then I had to call my ex-wife or whatever to come over there and pick me up because I lost my job in August or maybe into July. And when she come and picked me up, I didn't have a ride. She went back to work. And whenever she went back to work, I was homeless and everything. So I went to my friend Julia Collins out there in Maryville, and I didn't have a phone or anything completely. So then whenever her water electricity got shut off, I called Bishop Ricky Sinclair out there in Baton Rouge, and he came and picked me up in Maryville and brought me back over there. And I was in treatment from August and until September that he brought me into the parole office in Clinton because Officer Anderson told me to be there on the 29th. And as I went to go do my paperwork, they didn't have my paperwork ready. And then they told me to come back on September 3rd to the Clinton office. So I reported before lunchtime, and then whenever I went there, As soon as I walked in, they said I was arrested for attempted simple burglary in Clinton. They brought me to the St. Francis Parish Sheriff's Office. September 3rd, I was picked up on Monday, September 8th by two CSP officers, and they brought me to over here saying for a warrant. So as far as it goes, the stuff with Calcasieu, they have a whole different DOC number on this paper and everything. So I don't know what's going on about the charge part, but as far as me not absconding or anything, he come and see me May 2nd at my house before I left to go work at the fair. But April 30th, I had a 6-month pass to work in South Dakota as well. So I never absconded. I don't understand why Mr. Anderson stated that whenever Mr. Myers was my officer. So I don't know what was going on with that.
Well, he's saying that you did not report, not that he didn't see you.
No,
He's saying you didn't report and didn't turn
I
in.
didn't have a phone. By the time August hit, I did get a phone and call, and I sent up. He told me send a letter of acceptance. If you can send a letter of acceptance saying where you're at, I'm okay with it. Just stay there. How long is the program? I said it's a year long. He said, okay, well, as long as you have that paperwork and get sent to me, we're good. So then by the time I went to go check in that office over there to swap my parole from over here to over there, as soon as I walked in, they said, hey, you got a warrant Calcasieu, you're going to jail. That was it. But May for sure is a lie because he was there at my house on May 2nd. I know that for sure, and she can vouch on that.
But you didn't report to him. He reported to you, but you didn't report to him.
April 30th, I went to the office and got the parole pass.
30th. He's talking about May, June, and July.
Correct. Well,
Y'all talking about two different time periods. You talking about prior to what he's saying.
April 30th, I had a 6-month pass to work. I wasn't supposed to go back in the office. So May, he got switched to my new parole officer, and then that's when he just showed up the day I was leaving.
All right.
Whether you have a work pass or not, if you're in the state, you should be reporting.
Yes, ma'am, I did report. That's what I was still. Officer Myers is the one that told me. He texted me and said on my phone. He said, "You don't need to come into the office. Anything you need to do, just give us your name, your address, and where you're working, and that's all we need. We don't need to see you unless your name comes across our desk." His exact word.
All right, I understand. We can go on to number 4. You engage in criminal conduct which resulted in your being charged by the Calcasieu Parish Sheriff's Office with simple burglary. This charge is pending under Calcasieu District Attorney File 019-134-4945. It says back at the preliminary hearing, you admitted to the pending charge, but advised that you were told by your attorney that the charge would be dropped to criminal trespassing next week, a misdemeanor. So then you said you admitted to it, but now you're saying you're not guilty. You changed
I'm
it.
not guilty of attempted simple burglary, no, sir. I'm guilty of trespassing for sure. I was just wrong place at the wrong time.
But you still haven't pled guilty to none of that. It's set for trial on February 18th, right?
Hey, they pushed it till February 18th, yes, sir.
And you believe that they're gonna drop that charge to criminal trespassing?
Yes, sir.
You plan on pleading guilty to it?
Yes, sir, I do.
That's a violation of your parole. You do real.
Well, I mean, I was guilty of that for sure.
Okay. All right, that settles that one. And number 10, pay a supervision fee at the amount set by the Department of Corrections, and as of September of 2025, you had arrearages totaling
I want to say it was May, June, or May. Somewhere, I know I made 3 payments because I had the receipts for it, but I don't have them present right now. Because
right.
I did one over the phone, one over the internet, and I gave my other payment in the office, whatever. I had to go check in with the director when I was in the Anchor House.
All right. We have Dallas Amarine, your ex-wife, who would like to speak, and we'll go to her at this time.
Can y'all hear me?
Yep.
Okay, I'm not really sure. Do y'all have questions for me, or do I just talk?
Just talk.
Okay, so everything that he is saying is very accurate. Tristan Myers came to my house actually to see him a few times, and Tristan, I've been on probation with Tristan Myers before. I've been off for quite some time now, but he tells his people not to come into the office, that he will call if they need if they are needed to be seen. So if he did not, I know that he came here to see him, so he reported to Chris. Chris didn't report to him, but he tells the people that are on probation or parole with him that he will contact them if he needs to see them or talk to them, or if they need to come into the office. I want to also point out that as far as the new charges go, all he did was walk down the road with one of these little buddies, and that he had just met, might I add, and where they walked to, Chris did not know where they were going, but they walked down there, and it was a house that had been getting broken into and robbed by several people in this town. He did not engage in any criminal activity except for stepping foot on property that he shouldn't have, and he did not know. He was unaware completely of what was going on when it was going on. And as soon as he did, I have messages from people like admitting that Chris is in no fault for any of that. Also, I had where he was saying, because he checked himself back into that all the way house with Ricky Sinclair, and they mailed me 5 phones, and the one phone that has all these, and I know this is crazy, but the one phone that has all these messages that he is saying that he has, they're on there, but that one phone got lost in the mail. So, and I know that is just the worst coincidence in the world that could happen, but I will testify under oath that it got lost in transit to me. Chris he has a bad rap, and I get that. But this time around, he really was not doing anything bad. Like, he was spending a lot more time with his child. He was home a lot, and he went off to work for the fair, but whenever he lost his job, he spent most of his time with his kid. And as this kid's mother, that shows so much growth in him. Like, he really was trying to be the best that he could be. He was, and I am very optimistic and positive that this will be dropped down to a misdemeanor, because I have the not receipts, but I have the messages and stuff from these people stating that they know and that Chris didn't do anything. He did not steal nothing or have intentions to steal nothing. So I got to get with his lawyer, but it's definitely going to be dropped down to a misdemeanor, if not dropped all the way, because wrong place, wrong time, like he said. I just have to get with his lawyer. I am asking for y'all to give him leniency, because he really was doing good, and his child misses him a lot.
All right. Thank you for your input.
You're welcome.
Chris, I got a question for you.
Yes, sir.
You know, you saying that you're innocent of the charge, and that, but the police have a Ring video doorbell footage showing you and your partner walking up on the porch, and you bending over particularly and pulling on the window that had been broken in to several times before. And I was just wondering, what were y'all doing at that house? What were you there for?
I was told by him that he was going over there to go get some money that a guy owed him. By the time I walked up to the door and walked up to the window, I see nobody was there. And I was like, bro, I said, I don't know what you're doing here, but they say nobody lives here. So he turned around, walked to the door, and there was a Ring doorbell there. I took a lighter out of my pocket and I lighted. I said, bro, that's a camera. Nobody's staying here. He's like, what? And I light the lighter. Yeah, I said, that's a camera, bro. Nobody's living here. And would turn around and walk straight back down the driveway, and that's it.
So you're saying you went there to collect some money that
he said the guy owed him some money. I wasn't aware of anything. He's like, hey, I just want to stop by over here and go get some money this guy owed me. So by the time walking there and seeing that nobody lived there, I was like, man, no, we gotta leave. Come on. And I turned around and left.
All right. I don't have any more questions.
I would like the record to reflect that Tristan Myers was not your supervising agent at the time that you were non-compliant and had violated absconding. Your supervising agent was Trey Anderson. Mr. Tillis, do you have any questions? Is the panel
I
prepared
do
to
have
vote?
one question also on the preliminary hearing paper that they had, they was telling me, do I want a preliminary hearing or do I want to defer it? Well, I told them I wanted to defer it, reflecting on the fact of, my charge is supposed to be misdemeanor and everything. Well, he said, okay, well, on top of that page, it says 9/5/25, and I wasn't even arrested over here until 9/8/25. So I don't understand why that page for the preliminary hearing says 9/5/25 on it when I wasn't even in this jail yet. I never even met him, never did anything yet with it or anything. So I don't understand why that page would have 9/5/25 whenever I was over here on 9/8/25.
Okay, there are times that simple clerical errors can be made. Okay, that is.
And that's what I'm trying to stress is the error that was made also by the sheriff's office over here was I wasn't burglarizing anyone, man.
Okay, we're dealing with the allegations of parole violation. Mr. Bob, this is your case.
I'm gonna vote to revoke parole based on continued criminal behavior and failing to follow the instructions of the parole officer.
Mr. Tillis.
My vote is to do not revoke.
My vote is to revoke based on non-compliance with your parole officer. So today, sir, by a vote of 2-1, your parole has been revoked. We wish you well.
So that was interesting to me just because the witness for him was his ex, and she ends by like bawling about it. So it kind of makes me wonder just how quote unquote ex they really are. But you know, whatever. Let's change it up. Let's go to Reno, Nevada. Always a fun cast of characters there. Judge O'Neill, say good morning.
Yes,
to
thank
her.
you. I'm aware of that. Thank you very much.
Buenos días.
Buenos días. Good morning.
Good morning, sir.
Buenos días, señor.
Mr. Martinez Ruiz, your case number is 25 CR 01581.
Su número de caso, señor, 25 CR 01581.
This is listed as a contempt hearing.
Estamos aquí, está presentado como una audiencia de desacato.
No sé, yo no sabía de eso.
I did not know about this.
All right, I'm going to go over that with you.
Lo voy a revisar con usted.
It looks like on January 31st, 2025,
Parece ser que el 31 de enero del 2025
you were found guilty of petty larceny.
le hallaron culpable de un hurto menor.
Sí.
And it looks like you were ordered to do some things relative to that petty larceny.
Le ordenaron que hiciera algunas cosas en relación a ese hurto menor.
Sí, y hice lo que pude.
Yes, and I did go, I did what I could.
Well, I'm going to read you the warrant under which you were arrested, so you'll understand completely why you're in jail.
Voy a revisar la orden de arresto por la cual le arrestaron para que usted entienda completamente por qué está en la cárcel.
All right, and it looks like you were ordered to reappear at the community court on August 27th, 2025.
Parece ser que le ordenaron que compareciera otra vez en el tribunal comunitario el 27 de agosto del 2025.
Did you appear at community court over at the library in August?
¿Apareció en el tribunal comunitario allí en la biblioteca en agosto?
Sí.
Yes.
And then they ordered you to do some things and they ordered you to come back. Did you come back after you were ordered to do those things?
Le ordenaron que hiciera unas cosas, señor, y luego le pidieron que usted tenía que volver. ¿Usted volvió luego después de hacer esas cosas?
Fui, pregunté, me dijeron que parecía que todo estaba ya bien. Yo pensé que ya todo se había cubierto.
I went, I asked if everything was fine, and they told me that everything was covered. That's what I thought.
Well, you're wrong. Obviously, you had some obligations to the court that you did not do, or they would not have issued a warrant for your arrest.
Entonces estaba equivocado, obviamente había algunas obligaciones que usted tenía que hacer con el tribunal, por eso, si no, no hubieran emitido una orden de arresto.
Ok. Que si me da la oportunidad de salir, pues yo hago lo que tenga yo que hacer para quitar esos cargos y quedar limpio.
Okay, if you can give me the opportunity of being released, and then maybe I can do whatever needs to be done with the charges.
How long,
About.
how long have you been in custody, Mr. Martinez Ruiz?
¿Cuánto tiempo lleva bajo custodia, señor Martínez Ruiz?
Desde el lunes en la mañana.
Since Monday in the morning.
All right, Ms. Aboitis Tanner, or Mr. McGinnis, do you have any objection to converting whatever his obligation is from the community court to time served?
Yeah, I looked it up. It looks like it was 8 hours of community service. I apologize, Mr. Interpreter.
Yes, I was going to ask. Entonces, para la señora Aboitis Tanner, para el señor Patrick McGuinness, si tienen alguna objeción a que se convierta el requisito que él tiene, se pague con el crédito por el plazo ya cumplido en la cárcel.
Okay.
No objection, Your Honor.
No hay objeción, su señoría.
Mr. Martinez Ruiz, then, do you admit that you failed to complete your community services ordered by the court?
Señor Martínez, entonces admite que usted falló en cumplir los servicios a la comunidad como el tribunal le ordenó.
Dígale que sí, porque yo no sabía, pero que estoy dispuesto a pagar lo que tengo que pagar.
Yes, because I didn't know about it, but I am willing to pay or anything that is needed.
All right, well, you were ordered to do 8 hours of community service.
Le ordenaron que hiciera 8 horas de servicios a la comunidad.
You did not do that community service.
No cumplió con las horas a la comunidad.
So I'm going to accept your admission that you are in contempt of court.
Voy a aceptar su admisión de que está en desacato con el tribunal.
Please keep in mind
Por favor, tenga en mente
that when a judge orders you to do something
que cuando un juez le ordena que usted haga algo
and you don't do it,
y no lo hace,
it's contempt of court,
es desacato al tribunal,
for which you could be sentenced up to 25 days in jail and fined up to $500.
por el cual le pudieran dar hasta 25 días en cárcel, hasta $500 de multa.
You understand that now, sir?
¿Entiende eso ahora, señor?
Sí.
Yes.
All right, and you understand your constitutional rights?
¿Entiende sus derechos constitucionales, señor?
Sí.
Yes.
Have you served in the United States military, sir?
¿Ha servido como militar en los Estados Unidos, señor?
No.
No.
The court will accept your admission as freely, voluntarily, and knowingly entered.
La jueza va a aceptar su declaración, se ha hecho libremente, voluntariamente, a sabiendas.
And I will sentence you to the time you've already served in custody, converting your 8 hours of community service to jail time.
Le voy a dar como sentencia el tiempo que ha servido ya bajo custodia. Voy a convertir las 8 horas de servicios a la comunidad al tiempo que usted ha pasado ya ahí en cárcel.
Do you understand the sentence?
¿Entendió la sentencia?
Sí, también.
Yes.
¿Eso quiere decir que puedo salir ahora, este día?
That means I am going to be released now, today.
Yes, today.
Sí, hoy.
Muchas gracias.
Thank you very much.
All right, good luck.
Buena suerte.
And thank you, Mr. Barrio, as always.
Thank you, Your Honor. We will have one more if Your Honor wants to do the case.
Yes, I do. It's
Thank
the Pedro Popcal.
Yes, and Your Honor, this is a relay interpreting English to Spanish, Spanish to Quechua. We have the Quechua interpreter on the phone connected to Zoom.
All right, very good. Good morning, Mr. Popcal.
Buenos días, señor Popcal.
Buenos días.
Sí. Let me ask the interpreter of Quechua, Your Honor, if she's there. ¿Está ahí para la intérprete de Quechua, por favor? Daisy.
Sí, acá estoy presente.
Okay,
sí, acá estoy presente.
Ok, vamos a empezar con el caso del señor. Ok, we are ready, Your Honor.
All right. Good morning, Mr. Popcal.
Buenos días, señor Popcal.
مساء الخير Popcal.
Thank you, Lorraine.
Muy buenos días.
Very good day.
You have 2 matters before the court this morning.
Tiene 2 asuntos con el tribunal hoy a la mañana.
The first matter is 24 TR 16511.
El primer caso es 24 TR 16511.
Napapal, natikla sa 24, natikla sa 24 siya.
And that is a series of traffic offenses from December 14th, 2024.
Es una serie de delitos de tráfico del 14 de diciembre del 2024.
Haan siyan, napapal si Rulit siya rabain siyan, haan na siya anak. Siya numsing Christian, maraksad ako Christian, sali 14 reli siya sinume siya.
The charges are no valid driver's license,
Los cargos son no tener licencia de conducir válida,
la pokbalaki si Rulit siya rapsan, haan anak la hure beresing sali tenamita injan.
the no insurance on your vehicle,
no tener seguro automotor en su vehículo,
Makahunak li seguro chore la elep alchit.
and having invalid or expired registration of your vehicle,
y tener el registro no válido o caducado en su vehículo.
Li registro de la elep alchit o sea amna bensari manak makachigiru la lehure la elep alchit.
you were given, first, do you understand those charges, sir?
Primero, ¿entiende esos cargos, señor?
Manakatawiru li jog siap alage.
Pues, mapahunakin basom?
Ajá, tengo una pregunta.
Yes, I have a question.
Well, my question to you first is if you appeared pursuant to the citation that was given to you at court on January the 14th, 2025.
Mi pregunta para usted primero es si usted compareció en el tribunal de acuerdo a la orden que tenía el 14 de enero del 2024.
Limpat om nais ben kuasa masat hulak sali la pokpal sis ke ha kwe sali 14 de reli enero reli siap bain sa masat hulak.
Pues, imo ko ninautan.
No tengo idea sobre eso.
Well, I do not have no idea about that.
Well, then, do you recall appearing in court on January the 14th, 2025?
Bueno, ¿se acuerda de haber comparecido en el tribunal el 14 de enero del 2025?
Masat hulak aquí sali 14 de enero reli siap 2025 sa.
Pues, sakal kaman dyan mo kung ninauta siyang kerukuanan na lewan.
La verdad no tengo idea sobre cómo está eso, hija.
To be honest, I have no idea about the situation with that.
All right. So we have our information is that you failed to appear, sir.
Tenemos nuestra información. Oh, perdón. Tenemos nuestra información que dice que usted tuvo una falta de comparecencia, señor.
Yo corre pasali ulul chid naklaat magkusat kulakta sa lapok al.
Pues, ikaw siyang hulak, pues, mali siyang hultika, ustrok tingyan pa dyan, na naktingkwa sa ko salin tanimit pas, han sa kali pakompas na tinghulak rin yung family salin chon.
La verdad, yo no llegué. Lo único que pido es que tengo una orden de deportación, me pueden mandar y lo único que quiero llegar es bien con mi familia.
Okay. To be honest, I did not arrive to that. The only thing I'm asking is if I have a deportation order, I want that to happen and I want to be returned okay to my family.
I'm not in charge of deportation. I'm in charge of criminal matters.
Yo no estoy a cargo de la deportación, yo estoy a cargo de los asuntos por lo penal.
Lain, magkulain ng gintaklan rin, mantagtukis sa tinamit, malaking ka. Lain, kasi yogis ke palasik, arula, kakilal sa taong sa tinamit.
And I'm going to ask you a series of questions, sir, now.
Señor, sorry, Your Honor.
The first is, do you have a valid driver's license?
Señor, le voy a hacer una serie de preguntas ahora. El primero es, señor, ¿usted tiene una licencia de conducir válida?
Maus la licencia, pues masabi la licencia
Pues lain lintoh lin seguranza chujunil tohbil chujunil mag ahonak kaltil.
Pues yo he pagado todo el tiempo, tengo todo en orden.
Well, I have been paying the whole time. Everything is in order.
That's not my question. This is a yes or no question.
No es mi pregunta, señor. Es una pregunta de respuesta de sí o no.
Lipat om si siya kesan ma kwan si chabil ma le usa ta sume ma ehe malaking tao ma kwan si chabil lahu.
Do you have a valid driver's license for the state of Nevada?
Tiene una licencia de conducir válida para el estado de Nevada.
Mag ein license.
No.
No.
Did you have insurance on your vehicle on December the 14th, 2024?
Tenía aseguranza en su vehículo el 14 de diciembre del 2024.
Makuha ko naka-aseguranza sa la camión sa 14 de diciembre del 2024.
Yo creo que cuan, pero ang kuha de chili cuan gikin na nakpan halanchik.
Yo creo que si tenía lo que yo tengo ahorita, ya no es lo mismo.
I do think I had it, but what I have right now, it's not the same.
Can you provide proof of insurance?
¿Puede proporcionar prueba de la aseguranza?
Makuha na kikin na nakpan rin naktakot le nakpan na kikin na nakpan.
Mag gikin na nakan. Pues lichokin chichis.
No lo cargo ahorita.
Lichokin chichis ber singila nakam ko cuando chisinkawa chisinkawa huni kwami kwan.
Ya no lo tengo ahorita porque está el nombre de mi amigo. Esa.
Okay, so I don't have it with me right now, and I also don't have it. It's under my friend's name now.
All right. And then was the vehicle registered on the date in question?
Okay, ¿y el vehículo estaba registrado en el día en cuestión?
Tip ma-registrado kulman ni Raylala.
Barkwan mali lihunshil siya ko matohan chikili nakwan.
¿Cuál caso? ¿El anterior o el caso o el nuevo caso?
Which case, the prior case or the new case?
The registration on your car that you were driving on December the 14th, 2024.
El registro en su vehículo que estaba conduciendo el 14 de diciembre del 2024.
Sí, con sinkawan.
O sea, está mi nombre.
That was under my name.
All right, was your car registered on the date in question?
El vehículo estaba registrado en el día en cuestión.
Sa cuestión ma-registrado
Es registrado.
Sí, está registrado.
Yes, it is registered.
All right. I'll ask the city attorney if she is prepared to tender an offer to Mr. Popcall relative to the traffic charges.
Okay, voy a preguntar a la abogada de la... I'm sorry. Bueno, voy a preguntar a la abogada de la ciudad si está dispuesta a ofrecer una oferta en cuanto a los cargos del señor Popcall.
If I may, Your Honor, he has the DUI and his traffic charges. He's going to enter a not guilty plea. He wants these all set for trial.
All right.
Okay.
Mr. McGinnis.
Should I say that, Your Honor, through the interpreter? Entonces, el abogado McGuinness ha dicho que el señor tiene un DUI y se va a declarar no culpable a todo por el día de hoy.
Las pinulrisin sa kalap sa siya anak sa likutanaan makot esketa lima sa laben.
Is that what you want to do here this morning, Mr. Popcall? Enter pleas of not guilty to all charges.
Es lo que quiere hacer hoy aquí a la mañana, señor Popcall, declararse no culpable a todos los cargos.
Pero takwas anong gisiru la nakpan na rin porque yo que sepa nak ingat es que ni masa nas manak no culpable yo que sepa la question.
Pero matingruang CL nakting kirah naktin resira kanakan o manaking ka chanro di pregunta san.
Me pueden sacar, o sea, si yo digo no culpable, acepto el no culpable, ¿me puedo salir de aquí hoy o cómo está eso?
But if I do say or plead not guilty today, am I going to be released today from here? How does that work?
Basically, I don't negotiate with people relative to their entry of plea.
Básicamente yo no puedo negociar con las personas en relación a lo que es cómo ellos se declaran.
I will set the matter for trial. Oh, sorry.
Yo que sepa la anak lain mo ko ni negosita anak ma chan kiru nak mata jena kay he mata jena kay a.
I'll set the matter for trial and appoint a lawyer for you. Then we will discuss whether or not you can be released on your own recognizance or on bail.
Voy a fijar una fecha para el juicio, voy a asignar a un defensor legal y luego hablaremos de si a usted le dejamos salir bajo palabra o si va a haber una fianza.
Entonces, kung nakahanawara li sa karap sa marakasi kung nakahanawara li sa karap korre atin renakto atin naksibisaan rinaan sa matruk tap kakok jadi atin matruk tap kakok rin hunakafian sa maraktato hunakafian.
Pues, casquito cali, cuajomlein kamali jintiana. Akuangin reportación tiene que cumplir o ana cuaj balak ekchuli chagram nakshim paldo chak que tiempo nakshim kulon inmigración pues. Cuando reportación tiene que cumplir, tiene que
Muy bien. Si tengo una orden de deportación, muy bien, tendría que cumplir con la ley si me mandan deportado. Si yo ya no quiero faltarle el respeto a la ley acá.
Okay. So if I do have a deportation order, I do want to follow that. I do want to obey the law and do that deportation order. I want to comply with the law.
We're not talking about deportation now. We're talking about a trial for the crime of DUI that's been alleged against you.
No estamos hablando de la deportación ahora, estamos hablando de un cargo por un delito de DUI, de manejar bajo los efectos que se alega contra usted.
Nakuan mo ko yo ko tamasi at nagsis deportasyon din. Nakuan yo ko lo bangkit sa ko nakuan ko na tahkilan sirulit sa aran sa alin sa linimlat namin anak yo kat ere singi ere bangkit nak kalahan nakat marak yo klaha.
Así ya. Pero que cuando hay oportunidad chicana karim pues truang tin el karim pues teshke injonal pues teshkui max libar que shimpalto ko tin chak chili vele bachit.
Muy bien, si me dan una oportunidad de quedarme aquí en este país, muy bien, yo cumpliría con la ley que ustedes me están dando, que yo ya no puedo tomar ni tampoco manejar bajo efectos de licor.
Okay, so if you let me stay in this country, I would follow the law and do what the law says, and also not drink and drive like the law says.
I'll go ahead and accept your not guilty plea. I'll appoint a lawyer to represent you and we'll set the matter for trial now.
Voy a aceptar su declaración de no culpable, voy a asignar a un defensor legal que le va a ayudar y voy a fijar una fecha para el juicio ahora.
Anak kwansan, okay, si paal kunak li defensor sa manak li koloka ke tirulit sa arap sa rena kasi kunak li fecha rela juicio.
May I have a trial date with a legal defender for Mr. Popcal?
Una fecha para el juicio con un defensor legal para el señor Popcal.
Kasi anak li fecha sa rela kawa Popcal rena tirulit raklep atin.
January 20th at 8 a.m. with Mr. Puentes.
Mr. Popcal, the trial for your DUI has been set for January the 20th, 2026, and your assigned lawyer is Roberto Puentes, a Spanish speaker.
Señor Popcal, su fecha para el juicio ha sido fijada para el 20 de enero 2026, 8 de la mañana. Su abogado es el señor Puentes. Él habla español.
Sali 20 de enero reli siap sare manak li po sare aran sa tik sare raklep sakrap san li hunak li anit otmenin sa kake manak na bor li sakrap haan li kawa Puentes haan otmenin kake kan.
Has bail been set in this matter?
¿Se ha fijado la fianza en este asunto?
Your Honor, I only see. I'm sorry.
Es que es una fianza question.
I only see
Adelante.
a $2,000 holding bail, and I don't see that he's had a bail hearing.
Solo veo una fianza de $2,000 que le está reteniendo. No veo que haya tenido una audiencia para la fianza.
Kasi nagkilsa de ulul na kung una fianza le toje tras really $1,000.
I see a $10,000 cash-only bail set by the reviewing court.
Veo una fianza de $10,000 a pagar solamente en efectivo que se fijó por el juez que revisó el caso.
Para que una fianza de las $10,000 te tojen dices que fijara question.
Your Honor, Mr. McGinnis may have some more information on this, but I'm looking at the judicial bail order that is attached to the defendant's case. And there's a $2,000 bondable bail signed by Judge Hazlett Stevens.
Okay. Estoy mirando la orden de fianza judicial. En esa orden de fianza judicial hay $2,000 con garantía de fianza. Está firmado por el juez Hazlett Stevens.
Cuando una fianza de $2,000 se me dio en que fijara que las nahuatl le sacaron.
Now, if I look at the jail list, I did notice that there's a $10,000 bondable bail listed there.
Ahora, si miro la lista de la cárcel, veo que hay una fianza de $10,000 listada ahí.
Yo que no quiero avanzar junto el listado, no juego una fianza de $10,000 a fianza.
I'll hear from Mr. McGinnis relative to any information he may have.
Escucharé del señor McGinnis en relación a cualquier información que él pueda tener.
Yeah, Odyssey shows that he had a hearing on 12/9 and a $10,000 cash only was set. I don't know if that was a bail hearing or not.
I'm sorry. So, Odyssey muestra que el 9 de diciembre tuvo una audiencia, se fijó una fianza de $10,000. No sé si hubo una audiencia para la fianza o no.
Yo que sé para el 9 de diciembre es cuando una audiencia porque es que fijara que le fianza antes, que no te más tulak.
Well, I think that we have a confusion here relative to the amount of bail that's been applied to Mr. Popcall's matter.
Bueno, creo que tenemos una confusión aquí en cuanto a la fianza que ha sido aplicada al caso del señor Popcall.
Bueno, yo quiero para que eres na cuando una clasificación le fianza dices que ha cuesta.
So shall we, I hate to set this matter over until tomorrow, but I think to avoid any confusion or any information that may be relevant relative to Mr. Popcall's bail status, we need to clarify this situation.
Ok, deberíamos fijar esto para mañana porque pienso que la información que tenemos o cualquier confusión que podamos tener, quizás sería mejor para mañana para establecer mejor esta fianza.
Maran el julas patolog chikan chiru chicha wilayan porque satsoko bayak en la fianza.
And Your Honor, if I may, my understanding is that the 12/9 hearing was continued because Mr. Popcall did not have an interpreter yesterday.
May the interpreter of Spanish clarify something, Your Honor, because the interpreter of Spanish was there yesterday, but I do not know if this is the correct moment or not.
This is the correct moment. Thank you.
Okay. So the hearing yesterday was mainly conducted in Spanish. Mr. Popcall has about 40% understanding of the Spanish language. And that's how that hearing was conducted yesterday. We said the Kekchi interpreter for today, the $10,000 bail, as far as this interpreter understands, was set as a holding bail by Judge Hazlett Stevens, but no bail hearing as far as this interpreter understands.
Very good. Thank you, Mr. Barrio.
Thank you. Should I now say that to...
Yes, please.
Ok, para la intérprete de Kekchi, por favor, la intérprete de español estaba clarificando que ayer hubo una audiencia con el señor Popcall en español y que hoy se programó para Kekchi. Si le puede decir, por favor.
¿Perdón?
Perdón, ¿entendió esa parte?
No, por un poquito de ruido no entendí muy bien.
I'm gonna repeat, Your Honor, there was some noise she couldn't hear.
Okay.
Okay, entonces, para la intérprete Kekchi, por favor, estamos diciendo que ayer tuvimos la audiencia en español con el señor Popcal, hoy lo estamos haciendo en Kekchi. Ayer se fijó una fianza de $10,000 para retenerle por el juez, pero todavía no hemos tenido la audiencia para la fianza.
Yo que lo banque se kuna que la kis kwa hun la audiencia o sea se pone aquí sale la sala de kiersen te kaslan adin jan ko 50 le inse yang pero nak pan yo que lo banque se kusa katino al fc nak kiers es que fijar una fianza de $10,000.
All right, at this time, I'll hear from the city attorney relative to her request as to a bail amount.
Entonces, escucharé ahora por parte de la abogada de la ciudad en su petición para determinar esta cantidad para la fianza.
Anak kwan kam ilah na wala sa arap reli tenamik kwan kopi ten rena fa fijar la fianza nak pan.
Thank you, Your Honor. On the NPRA, the defendant scores a 7.
Gracias, su señoría. En la evaluación de riesgos, el acusado tiene una puntuación de 7.
Anak kwan na wala sa arap mas makorrera atin yo kaya kung puntuación de 7.
The defendant reported that he's been in the Reno area for 5 years and at the address on file for 3 years.
El acusado reportó que ha estado en el área de Reno por 5 años, en la dirección que tenemos en el expediente por 3 años.
Yo creo asa de justo na kwan hun le na khajra la hobja kwan hun na khajra la hobja.
He reported being with his current employer for the last 2 years employed full-time in construction.
Reportó haber estado con su empleador actual por 2 años, trabajando a tiempo completo en construcción.
Trabajé con sali construcción.
The defendant, Your Honor, has an ICE hold as of December 6th.
El acusado, su señoría, tiene una retención de migración a día de 6 de diciembre.
Cuando una orden de deportación aquí en China sale el por diciembre.
As far as what's alleged in the probable cause statement, we learned that Mr. Popcal was allegedly involved in a single vehicle crash.
En cuanto a lo que se alega en los motivos fundados, hemos sabido que el señor Popcal supuestamente estuvo involucrado en un accidente con vehículo único. One moment, please.
Yo sé más que le jugaría nakla siya involucrado que manak siya huli accidente porque siya.
Okay, well, I think we've got the idea here as they figure out what bail is going to be, but I did look up something interesting. Now let me find it because I've lost. Oh, here it is. Okay. So this is the first time here at TCF where we've seen like nested interpreters, an interpreter speaking to an interpreter who then interprets for the defendant. But to give you just a little bit of clarity on the burden on the system to do this, I looked up some data, and you know, it varies across the country, but the average across the United States is $70 an hour for an interpreter with a 2-hour minimum plus any travel expenses, times that by 2. So just to have this interaction alone was what, $300. So it's crazy what this costs to pull this off. Just thought I would share. I found that interesting because, you know, we talked last night on Sidebar, different topic, but one of the things that came up was the resources that have to be used and how there's always funding issues and stuff like that. This was a serious funding issue to pull this off because they obviously didn't have a straight English to, what was it, Kekchi option. So they had to go to Spanish first, and doubles the cost of something that's already super expensive to do. So just found it interesting. Let me know what you think in the chat. Let's go back to Louisiana. Try that again.
Panel in the last hearing. So Mr. Tillis to my left, Barrod to my right, and Ms. Ledoux. Would you state your name and your DEC number for the record?
Sean Thomas, DOC number 753190.
Okay, Mr. Thomas, do you have a parole revocation questionnaire in front of you?
Yes, ma'am.
Do you recognize your signature on that?
Yes, ma'am.
Okay, that indicates that you're not eligible for appointed counsel. Have you hired an attorney?
No, ma'am.
Mr. Thomas, I'm going to read the allegations against you, and I need for you to enter a plea of guilty with a statement, or not guilty. Is that clear?
Yes, ma'am.
Okay. You have been accused of violating condition number 2 of your parole, in that you did not report to the Office of Probation and Parole since 1/10 of 2024. How do you plead to that?
Not guilty, ma'am. With a statement.
With a statement. Well, not guilty. Number 3, you were not living at the last address you provided to probation and parole of 608 Elaine Street in Lake Charles. Attempts were made to see the subject at this location, and he tried to make contact with the subject via telephone. All attempts were unsuccessful, and your whereabouts were unknown until your arrest 9/29/2025. How do you plead?
I plead guilty, ma'am, with a statement.
With a statement. Okay. I'm going to allow Mr. Barra to question you on those.
All right, Mr. Thomas, on violation number 2, at the preliminary hearing, you admitted to not reporting for the designated months, but followed up by stating that you did report in August, and now you're saying you're not guilty. I don't see how anything could have changed since then.
It's because, sir, I checked the dates when I was released from here. I was released in 12/7/23. So if I had to report it, I haven't reported in 24, and my parole officer was Stephen Smith. He should have revoked me there on that first. I had a misconception. My times was messed up. I had a hard time remembering, but I knew I got released in 2023.
Well, going back to the preliminary hearing and the findings there, at that point, you did admit to not reporting for the designated months, which would have been since January 1st of 2024 until August of 2024, those 7 months, but followed up by reporting August of 2024. The subject stated that when he reported in August of 2024, he was told that he had a new officer and never returned to report. When asked why you never returned to report, the subject stated that he was under the impression that his parole may have been terminated early. Why would you think your parole was terminated early?
Because when I went to see Stephen Smith, they told me it wasn't my parole officer anymore.
So that's why you thought your parole was...
I kept coming back, and they kept telling me the same thing, that he's not here, they don't need to see me. They didn't tell me who my new parole officer was till I got arrested at this time, so.
Mm-hmm. So we see that you're a 5th felony offender. On 5 rounds, you don't realize that you have to report to the parole officer no matter what, whether they return your calls or not.
I still did, sir.
You still reported, but only the month of August.
It's one thing, if it's not on document, my parole officer told me all I had to do was call and check. I was homeless, living homeless, coming home from the penitentiary and going back and forth and trying to transition to work for myself, with no parole officer to help me get a job, with no parole officer to help me get any clothes, food, or anything. So I had to do what I had to do, but still reported every month or every Wednesday and Friday when he told me he would be in the office, and when I reported, he wasn't there.
And when you reported, what did you do? Did you leave a report? Did you fill out a report?
I left a new number every time I tried to. Every time I told him to get in touch with me at this number, this number, this number.
Did you write out any reports? Did you fill out any reports?
Signed in.
What number was to tell him what your new address was? Did you fill out anything like that?
Yes, sir.
You left that every time you went?
Every time I went there, sir.
All right.
Jill Walker, I don't even know who she is.
All right. On violation number 3, You pled guilty at the preliminary hearing and you pled guilty just now with a statement. So go ahead and tell us what your statement is.
My statement is if I was at that address, that means there had to have been some place and some time that I've been reporting way after 1 of January 10th of 2024. If they had that document, whenever I gave them that documented address, that was after 12 or 23.
So it also says at the preliminary hearing that you admitted to moving from your last listed residence and not providing the Office of Probation and Parole with a correct address or phone number. And the subject stated that he was temporarily homeless without a phone. The subject stated that he was attempting to get his life in order before reporting back to probation and parole. Is that a true fact?
That's partially true, sir. I ain't have a number, but every time I got a new phone, I gave them a new number. I told them where I would have been at. I was at certain homeless shelters. I told them where they could find me there. He never pulled up on me. He never called none of those numbers, never texted none of the phones I gave him. But personally, me being homeless, I lose phones, things happen.
So you're saying you told him what the new number was and you told him what the new address was?
Every time I reported, sir.
Just now said you never saw him.
I seen him once or twice.
So how are you telling him what your new number and your new address is if you never saw him?
In the front desk of the office, and they telling me to go ahead.
Okay.
That's what I'm doing, sir.
And Officer Walker provided case narratives that indicate attempted contact by the subject by phone and at his residence. And the narrative reflected that the subject was arrested due to the active parole warrant. I don't have any more questions. Does anybody here have questions?
I just noticed non-compliance with day reporting center, having problems getting there, going to appointments, positive drug screens. You've had several issues during this period of supervision. Mr. Tillis.
I'm ready to vote.
Mr. Balron.
All right, Mr. Thomas, based on the facts provided at the preliminary hearing by the officer and the testimony provided by you, I see that you violated condition number 2 and condition number 3, and have no choice but to recommend revocation of parole based on those violations.
Mr. Tillis.
I concur with Mr. Balrock on violations 2 and 3.
My vote is also to revoke parole based on non-compliance. So, Mr. Thomas, your parole has been revoked today. That concludes the business before the panel. It's 9:12, and we're going to be signing off at Calcasieu.
Okie dokie, friends. Let's go back to Judge Simpson. Let's do that.
In our office, which I that Mr. Cleveland is currently in custody in Flint at the jail, and that Mr. Amadeo represents him on his Flint matters. So that's where he is.
Okay.
I don't have how long he's been there or how long he'll be there.
Were you able to check XDL to see if?
I was able to see VineLink, but
Okay.
the last update that when I looked at VineLink, the status update is Wednesday, the 26th of November. So I don't know if that's updated or not, but it did show that he was in there on that date.
On Wednesday?
That was correct. The Wednesday, the 26th of November.
Okay. What I'll do then is I'm gonna issue a warrant for him so that if they've got him, they'll hold him. Maybe we'll go get him or do whatever.
I don't know for a fact if it aligns with his incarceration in Flint or not, but I did know that then there was a community corrections violation.
Yes.
But
So bench warrant will issue bond 10,000 cash surety. I'll have that warrant issue immediately.
thank you.
Court calls case of People versus Benjamin Detlefs.
Good morning, Assistant Bones, but Lord Attorney on behalf of Detlefs. Mr. Detlefs, please yourself and state your name, please.
Good morning, Your Honor. Benjamin David Detlefs.
Thank you.
Your Honor, today is the date and time set for sentencing. We don't have any changes to the pre-sentence report. We do ask that you adopt the recommendation.
All right, Mr. Detlefs, anything you want to say before I impose sentence?
No, Your Honor.
$125 statutory fee, 350 days, Washington County Jail credit, 350 served. All right. Thank you, sir.
Thank you, Your Honor.
Court calls case, People versus Deja Ferris.
Good morning, Assistant Public Defender Lauren County on behalf of Ms. Ferris. Ms. Ferris, take me record, please.
She is not checked in.
Your Honor, I did speak with her. I don't have an explanation for her ability here. I request an adjournment.
Okay. Bench warrant will issue, pound 5,000.
I'm here. I'm here.
Oh,
My
you're
phone-
here. Okay,
My phone was
she's
on mute. I couldn't get it off. I'm sorry.
okay. We didn't have your name there, and you didn't answer. Got it. Now we got your name. Okay, go ahead.
Your Honor, today is the date and time set for sentencing. We did review the pre-sentence report. Don't have any material changes or deletions. We do ask that you adopt the recommendation.
All right, Ms. Ferris, anything you want to say before I impose sentence?
No, just wanted to say I just needed a little more time to pay my fees and fines and costs.
All right. Sentence of the court, $480 fines and costs, 93 days in jail, suspended. How are you going to get that paid?
I'm looking for work now. It's kind of been hard to find employment.
All right, here's what I'm going to do. I'm going to indicate this is going to be due and payable by January 31st, 2026. All right, give you a couple months to figure that out. Okay?
Okay, thank you.
Thank you. Court calls the case, People versus Aaron Griggs.
Well, alrighty then. I guess we're not going to hear People versus Aaron Griggs. Why do these judges always do that? Makes me sad. You know how hard it is, judges, to run a court channel when you keep just deleting your streams like mid-sentence? Do you have any consideration for those of us out here trying to do good for the society and show your stuff and present you in a good light and all these things? I tell you. All right, off my soapbox. Back to Louisiana.
That you've been appointed counsel, and we have Mr. Danny Engelberg.
Good morning. Good morning.
Mr. Engelberg, please interject and guide your client as you need. We will need for him to enter the plea, though. Okay.
Yes, Your Honor. We're not disputing the findings of the preliminary hearing. We have 3 witnesses today, an explanation, and a plan for success upon reentry.
Okay, great. We'll go ahead and read these allegations then. Violation number 2, you failed to report as directed on 1/8/2025. How do you plead?
Guilty.
Number 3, I will live on the address on the certificate. If I must move from this address, I will get permission from my parole officer before doing so. Not leave the state of Louisiana without written permission from the parole officer. An attempt to visit your address of record on 1/8/2025 and 2/21/25 were unsuccessful. How do you plead?
Guilty, yes, not guilty. I'm not understanding what you said. I didn't hear what you said. Sorry.
Okay, we're having a difficult time understanding because of the noise. Is there a lot of noise in the background there?
Yes, ma'am. Yes, ma'am.
Okay, did you enter a plea of guilty, not guilty, or guilty with a statement?
Guilty with a statement.
Dispense with violation number 4. because we did not see any arrest for a new criminal activity. Number 6, you failed to provide employment verification. Guilty, not guilty?
Not guilty. I don't understand what you mean about a permanent verification.
All right, this is unwatchable with that audio. Let's go to Reno.
Good morning.
Mr. Seve, I have a number of matters, 1, 2, 3, 4 matters for you here today.
Trespassing?
I'm required by law to go over each and every one of those with you so you understand why you're in custody.
Okay.
So the first matter, sir, is labeled a revocation hearing. And that is case 25 CR 08135.
You got a pen? I need to write this down.
All right. I'm going to go over each and every matter with you so you'll understand what's happening.
Take
So
your time,
first,
Mom.
the first matter, Mr. Seve, if you'll just listen, we'll get through these faster, okay? All right, and that is it looks like you were found guilty on June the 10th, 2025 with obstructing and resisting a police officer by physical force.
I didn't take time for that.
Well, we'll see. It looks like you got a suspended sentence. I'm looking to see if I have that information. All right, so it looks like you got a response from the Reno Municipal Court relative to that charge. That response was sent to you on July 21st. Tara Bailey from the Reno Municipal Court indicated as follows. Hi, Max, I'm following up on our conversation. You were seen and sentenced by the judge while you were in custody at the Washoe County Jail in order to report to the Reno Municipal Court when you were released on July 21st, 2025 to set up conditions, one of which is testing at Sober 24 for 30 days. As of today, you had not reported to the court and a probation violation could be issued for your arrest. So you were given the date and time and all that information, and it looks like you did not report to the Reno Municipal Court to set up conditions of testing for 30 days. Do you understand that, sir?
Yeah, I understand that. So I got released on July 21st. She calls my sister and tells me that I was supposed to do that. But when I got released, deputies told me I didn't have to report to anything when I got released. They didn't say I had to report to Reno Municipal Court or anything. So I got upset, but I did go to Reno 24 Hours and try to sign up to do a piss test. They said that I wasn't that I wasn't even supposed to beat her or whatever. So I left. I checked in twice, but that was on July 21st when I got released. Deputies said that I didn't have to check up with court or anything. I was just gonna really keep on, man.
Well, you appear to be a pretty smart guy who can understand English. So if the judge ordered you to report to the Reno Municipal Court, the court responded that you did not report. So you're in violation of the court's order to report to the Reno Municipal Court and set up your testing.
And that's
So
in downtown Reno.
the deputies aren't in control of your case. The judge is, and the judge ordered you to report to the Reno Municipal Court, and you did not. Do you understand that, sir?
Yeah.
All right. So, and I don't see that there is an underlying sentence. Could someone help me if there is an underlying or suspended sentence for that obstructing and resisting charge?
There is, Your Honor. It looks like on June 12th, 2025, he was sentenced to a 90-day suspended sentence with 60 days to be served up front, consecutive to another case. So it looks like there's 30 days hanging over his head. Conditions were the no drugs and alcohol, obey all laws, and the 30 days of testing.
All right. So do you understand that, Mr. Seve?
Yeah, I heard that.
Okay. All right. I'm going to move on with the next matter because if you are on a suspended sentence, you understand that the first rule of any suspended sentence is that you obey all laws. So if you got arrested and you enter a plea of guilty or no contest to any new charges, you could be facing revocation on that 30-day sentence. Do you understand?
Okay.
All right, so I'm going to go on to the next one, and that's 25 CR 18007. And I'm opening up that matter now, Mr. Seve. We'll see what that is. That's a trespassing from December the 2nd, 2025. Did you understand that charge?
Last year?
No, last
2025.
three weeks ago. Or no, sorry. No, yeah, today's the 10th, so 8 days ago.
So 2026. Oh yeah, at the pepper mill.
Okay, so you understand that charge, sir?
Yes, they gave me a citation, said that I had to come to court January 16th.
Okay, well, that's a pending charge, correct?
Yes.
All right, so I'm going to move on to the next one. You understand what that is, obviously. Let's go to the next one. The next one is 25 CR 18213. That is, Mr. Sevi, a charge of another trespassing on December the 7th, so 3 days ago. You understand that charge?
Yes. Oh, this at Atlantis, December 7th. Wow, I was making reservations.
Okay, all right, so don't say anything yet. You're presumed to be innocent of those charges. You may get, the city attorney may tender you an offer. The last matter I have for you, sir, item number 4 is 25 CR, 18261. And that is another trespass from December the 5th. So it looks like you have trespasses from December the 2nd, the 5th, and the 7th. You understand that, sir?
Yes, Your Honor.
All right. And you also understand that if you enter a plea of guilty or no contest, you could be looking at revocation of the 30-day sentence, correct?
Yes.
All right. Ms. Boydis Tanner?
Thank
Is
you, Your
the
Honor.
city prepared to tender an offer, if any, to Mr. Seve?
Thank you, Your Honor. And Mr. Seve is willing to plead to the Atlantis trespass from December 7th and the GSR trespass from December 5th. The city would move to dismiss the Peppermill trespass, which was a citation from December 2nd.
You want to accept that offer, Mr. Seve?
I accept it.
All right, sir. And what is your plea to the trespass on December the 7th in case 18213?
Can I talk to my attorney real quick, Patrick?
Yes, I'll ask that my staff remove Ms. Boydis Tanner and myself from the courtroom.
Hey, Patrick.
Hold on a minute.
Your Honor, I'm placing you in the waiting room.
All right, Max, what's up, buddy?
So you think it's smart just to plead guilty for this misunderstanding about my life? You know, my brother.
I like how you put that, Max. Okay, so you have 3 total cases that are new cases, plus the revocation case. You're only looking at 30 days on that revocation case. You have a Peppermill case, GSR case, and Atlantis case. They're going to dismiss 1, plead to 2, probably get revoked for those 30 days, be placed on another suspended sentence is what I'm thinking, okay?
All right, so I'm going for it?
I think so, just to close everything out.
Thanks, Uncle Patrick. I got it.
Okay, you're welcome, Max. All right, Michelle, we're ready. Thank you.
Michelle?
Mr. Seve, have you had enough time to speak with your lawyer about your decision to
Yes, Your
accept or
Honor.
not accept the offer?
Yes, Your Honor. I'm going to plead guilty.
All right, sir. And as to the other matter, which is case 25 CR 18261, What is your plea to that trespass?
Come again?
You've been offered to enter pleas of guilty to 2 trespasses.
Oh, yes, guilty.
The other one. So is your plea guilty to case 25 CR 18261?
Yes, guilty.
All right, and you understand, Mr. Seve, that by entering a plea of guilty, you're giving up your constitutional trial rights. Is that correct?
Yes.
Do you have any question about those rights, sir?
Not at the moment.
Okay, this is the moment you're being canvassed as to your plea. So if you have a question, you've had an opportunity to speak with your lawyer. You understand your constitutional trial rights.
Yes.
All right, and you understand that each of these trespassings are misdemeanor offenses for which you could be sentenced to up to 6 months in jail and fined up to $1,000 on each?
Yeah. Yes.
All right. And have you served in the United States military, sir?
Yes.
You're a veteran of what branch of the service?
The Semper Fi for Sicilian Mafioso for my grandpa Robert Valdez, who lost 40 acres in Oxnard. For the Hands of Hope, Father Aya Kevin Seven. For the veterans, community, and the homeless.
All right. Have you actually served in the military?
Actually, I'm gonna say no then.
Thank you. I appreciate your honesty.
Yeah, all right.
The court will accept
I know a
your,
lot of veterans.
hold on, it's my turn to talk.
Yeah.
The court will accept your pleas of guilty to the 2 trespassing charges as freely, voluntarily, and knowingly entered. I will dismiss the peppermill trespass contained in 25 CR 18007, and I will hear from the city relative to sentencing in this matter. I will give you the opportunity to speak to me, Mr. Seve, when it's your turn, okay?
Thank you, Your Honor.
Go ahead, Mr. Boyce Tanner.
Thank you. For the record, the revocation case, he was ordered to stay away from a casino, J Resort. That's important because he's back on casino trespass cases. So what I'm going to ask is that you revoke on those 30 days remaining on that suspended sentence case. As far as the 2 cases he pled to, he's been in and out of our court since 2018, and I count at least 40 cases. He's been in and out of jail on those cases. It appears that he gets placed on suspended sentences as he's ultimately revoked. He's got many trespasses, but he's also escalated to simple batteries, obstructing and resisting an officer. And I don't know what the rest of his criminal history looks like, but over the last 7 years in our court, he has been active and committing all kinds of different offenses in our community. It doesn't seem like a suspended sentence works for him. Based on the way he presented today, Your Honor, it appears that Mr. Seve has a clear understanding that he's not supposed to be in these casinos, but he makes a decision to go to these casinos. And the suspended sentences in a few days in jail have not done the trick to make him understand that there would be serious consequences if he continues to go back to these businesses. So with that, Your Honor, what I'm going to ask for is that you impose an additional 30 days on one of those cases, and that to prevent this behavior in the future, that you impose a maximum suspended sentence in the remaining case. I understand generally we don't do that in these casino trespass cases, but Mr. Seve is not getting the message. Maybe if he understands that if he goes back to a casino he's not supposed to be at, he's going to be facing 6 months in jail, maybe that will change his behavior. Thank you.
Thank you, Mr. Boyce Tanner. Mr. McGinnis, on behalf of Mr. Seve.
Thank you, Your Honor. I've had an opportunity to interact with Max, Mr. Seve, on several occasions, including his family as well, his parents, namely his mother and father moved back to Samoa in 2015 or 16. After they moved back to Samoa, Max just seemed to really fall apart when they moved. His mother and father, while in Reno, his dad was a pastor and they operated a church, and he had a really good support system. Once they left, Max just fell apart. And as you can see, he's had numerous run-ins with the law enforcement. I think the positive twist I can put on that is he hasn't escalated to felony behavior. He hasn't gone to prison, which I think is, mitigating to a certain extent. Max tells me that if he's released from custody, he's going to go live with his sister, and he wants to go to the Victory Outreach Program, which I think would probably be in his best interest to go to the Victory Outreach Program. His grandfather is here in town, and he does have a church as well. It's called the New Foundation. I think Max needs to realize that there's people in this community that are willing to help them, including his sister and his grandfather. I think it would be in his best interest to go live with his parents back in Samoa, but he does not have his birth certificate. I don't know what this court can do to keep Mr. Sede from reoffending. Jail has not helped. Suspended sentences have not helped. I think Victory Outreach would help. I just hope that Mr. Sede finds some help here in the future, because eventually he's probably going to end up going to prison if he keeps going down this road, and I'll submit it, Judge.
Thank you very much. Mr. Sede, the law affords you the opportunity to speak to me. What would you like to tell me?
So, the casino issues and all that, my brother, he's the head security at the road. But we're talking about J. Paul, and this goes back to when it used to be Sands Regency. So they're trying to tell me that I can't be at the casinos, but I have memberships. But I don't have a valid ID. I have to go to the Money Ranch to get my actual valid ID so that I can go gamble, lounge, eat, and et cetera, and et cetera. But these offenses that they're trying to accuse me of, it's right and it's wrong at the same time, because they're trying to blame my family. But I only got my brother out here, my sister, and my grandfather of the church family. Like I said, we serve for the Hands of Hope for the veterans, community, and the homeless. But as for me right now, this being my 54, 10 misdemeanors with Sparks, 42 misdemeanors right here, and this is going to be an extra one. And I have one misdemeanor in Roseville that I do like to talk about because they simply gave me a notebook. I'm doing music and et cetera for work, but I just want to get this off my chest. I work for God, but I work with Jesus. I just wanted to put this all on recording. I got a lot of great friends out here, great family. The reason why I'm stuck out here is because I simply made a covenant with my dad when I was in 6th grade elementary. And I do plan to go to Samoa, talk to my father. Patrick knows the case with my childhood twin, Thomas Ayala 7. So I'm recording. He suicided himself from my mom. But as for me, I'm just trying to man up to the legacy that my dad left me with, and the love that my mom gave me, and etc. But where do I go from here? I just want to get released because it's going to be my 31st birthday. My kids are back. My sister has my kids. I want to see them. She's kind of upset because I didn't give her EBT. I just want to feed my kids again. And when I get released, I am going to go to the Victory Outreach Men Ministries in Carson City. I was in Grand Sierra. I already talked to Pastor Pepe that I was going to join them, but I was just late. But if I have to do these 30 days and another 30 days, 60 days, then it's going to just real facts. It's going to hurt my kids. It's going to hurt my kids. And I won't be able to talk to my dad in Samoa that I'm okay. And that's all it is. But if J. Paul wants to put that offense on me, I'm willing to man up and do those suspended sentences, because I'm not a gangster, but I have my family, will kill for me. My people will kill for me is all I'm saying. So I'll do those 60 days, and just wait for another Christmas to get this resolved.
Okay. So, Mr. Sede, I want to tell you a couple of things. These casinos, you say I want to sit and eat and have a lounge and hang out at these casinos. They're no different. They're private property. It's no different than someone coming into listen to me. I listen to you. So it's no difference of someone coming into your living room and saying, hey, I just want to hang out and lounge out and eat and hang out at your house. And you say, hey, I don't want you. I don't want you in my house. That's what these casinos have said to you, and you still come back and violate their privacy, their ability to keep people out that they don't want. So that's what trespassing is. And you trespassed 3 different times in almost a week with different places. I'm talking now, different places that had asked you not to leave and not come back. That's what trespassing is. And I want you to be very clear about that, because you think that you own the world. You just go back in whether or not they think they want you there or not. So I think that you do deserve to get the inside of a place where that you can hang out, lounge, and eat. But certainly you're going to be ordered to stay there. So I will revoke you on the 30 days. I'm going to send you to an additional 30 days, so 60 days in the Washoe County Jail. That additional 30 days will run consecutively. And then as to the new charge, I'm not going to follow the city attorney's request to sit for 6 months, but I'm going to sentence you to 90 days consecutive, and that will be suspended for a period of 1 year on the condition that you do not break the law again. But you have to stay away from these properties that have trespassed you. They have the legal ability to
Make a reservation.
Hold on. I don't care if you have reservations. I don't care if you're a member of one of the card playing. They can change their mind.
Yes.
Keep people out, and they do not want you there. So the GSR, the Peppermill, the J Casino, all of those places have asked you to leave. And if you don't leave again, you're going to get out of jail after doing 60 days. You're going to go back to one of those places. You're going to get rearrested, and guess what? You're going to do 90 days. So you must like going to jail, because you seem to be a very, very smart and articulate young man. But you need to, when you get out of jail, you need to go to Victory Outreach and start changing your ways. Do you understand?
Yeah.
That's my order.
All right, thank you.
Judge, can you give me the case numbers that you're
I'm a little bit exhausted after that one, to be honest with you. Guy's a character, I'll give him that. Thank heavens Uncle Patrick was there to help him out. But yeah, he's got some stuff going on. Alrighty, guys, I gotta let you go for today. Things I gotta do, people I gotta tend to, stuff like that. But we'll be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, and we have Sidebar tomorrow night too, at 8 p.m. Eastern, 5 p.m. Pacific. So lots of good programming for you tomorrow. And, of course, we've got videos posting throughout the day today, so be sure to check those out. Go have yourselves a good Wednesday. I look forward to seeing you tomorrow. Take care. God bless.